this not to disturb the list. One case is under the heading for order serial number 6.
CMP.
Second notice point पर है वो बहुत लोग मर गए जीते गए सब्स्टिट्यूशन हुआ नोटिस हुआ सब कुछ है
क्या बचा
इतना ही है कि पहले जो सिस्टम है 4 बजे वाला तो रहा नहीं
क्या करना है खत्म हो गया ये
तो चाहते हैं कि इसका हियरिंग में फाइनल डिस्पोजल वगैरह से तुरंत डिस्पोजल
बाकी एफआईआर हो गए सब लोग नोटिस वगैरह कंप्लीट है इसका
सेकंड एप्रिल में जो नोटिस पॉइंट
6 and 7
कभी कभी भी तैयार दो आदमी बात कर सी एक्चुअली पर सब्स्टिट्यूटेड सर्विस और डिस्प्यूट पोस्ट था सही बताइए फाइल को इन लोगों पर हम तो रेस्पोंडेंट था पेंशन का तो बनाएंगे हम मेंशन करना बहुत जरूरी है
तो ये हो गया सब्स्टिट्यूट सर्विस फाइल हो गया इसमें
और आप चेक करो नहीं लगता नहीं उसमें
नहीं होगा तो उसके अगेंस्ट में डिसमिस हो गया
हम उसको देख लेते हैं
देख लीजिए
हाँ कभी भी राइजिंग के पहले
4 बजे
सॉरी
4 बजे आ जाए ये आपका सीएमपी है
हाँ
नहीं इनका पहले सीएमपी कॉल सवा 2 बजे एक केस रखे हैं मिस्टर सानी सवा 2 बजे एक मैटर रखे हैं भले ही लेट हो लेकिन आपका वो थोड़ा फाइल देख के या सवा 2 ही बजे आ जाइएगा तो थोड़ा देख लेंगे फाइल क्या है नहीं तो उसके बाद हियरिंग शुरू हो जाएगा आप 5 बजे तक अननेसेसरी बैठना पड़ जाएगा तो सवा 2 बजे आ जाए ठीक है दैट वुड बी बेटर खाली रिकॉर्ड देख के देख लेंगे अगर होने लायक है तो कर लेंगे 2010 का सेकंड
हाँ और उसमें जब तक सर्विस नहीं
नोटिस
तो हो सकता है वो डिसमिस हो गया होगा एज अगेंस्ट देम क्योंकि हम तो प्रीएम्प्टिव ऑर्डर करते हैं
हमको नहीं लगता वो डिसमिस हुआ होगा लेकिन
ठीक है
चेक करना
चेक कर
From supplementary list for orders notified item 6 CMP file number 14981 of 2025.
बाकी हो गया डिफेक्टिव लिस्ट
बाकी वो दो आईए है और बाकी
अच्छा क्या चीज का
कि पिटिशनर नंबर 1 जो कनेक्टेड केस में है वो पार्टी नहीं है इस सीएमपी में बिकॉज़ ही हैज डाइड इन द ईयर 2007 so this legal as a file is CMP so
2007 में डेथ हो गया
हां 2007 में
2007 के बाद रिट पिटीशन लगा ही नहीं क्या
नहीं लगा तो कोविड के समय में टेक अप वो
2002 के बाद सीधे 2007 के बाद सीधे कोविड पहुंच गया 12 साल बाद यस रेस्टोर नहीं करेंगे हम अब इतना आसान मत समझिए रेस्टोरेशन विल बी डिफिकल्ट आई विल नॉट रेस्टोर इट there is a limit to which these kind of latches can be taken care of और ये क्या है there are 2 IAs no
टू आई एक तो वो कैसे करना होगा क्योंकि वो जो है एडीएसएन करना था वो कर दीजिए तो वो
ADS ने किसका ADS ने
जो नाम है ना उसमें वो डिफेंडेंट नंबर 4 का KURMI है एक जगह KAMI तो उसको खाली एडीएसएन करके दोनों का नाम ऐड कर दिया तो वो उसको प्रेस करने की जरूरत नहीं खाली एक आईए नोट जो कि पिटिशनर नंबर 1 एंड
आईए नंबर
आईए नंबर
1538 IA number 1581 of 2026. This petition has been filed for ignoring defect regarding name of respondent number 4 and respondent number 9. The learned counsel has submitted that he has put alias names. However, this defect is ignored subject to any objection that may be raised by the concerned party. IA closed. IA number 1538 of 2026. The Learned Council has submitted that the sole petitioner,
petition.
The petitioner number
One.
1
Yes.
had expired way back in 2007, and the writ petition has been dismissed, and consequently the petition for restoration has been filed by his legal heirs. He submits that the defect in connection with party possession be ignored. Considering the submissions, the IA number 1538 of 2026 regarding defect in party position is ignored for the present. Subject to any objection that may be raised by the respondents.
Notice to not divert respondent 4 to 10 minutes.
Let notice be issued to the
State appeal.
respondent number
4
4
to 10.
to 10. Through the concerned police station for which requisites be filed within the period of 1 week for entry. The counsel for the state is present, therefore no notice need be issued to respond number
1 to
1, 2 and 3. Post on 27th February. The meetings are distributed.
The mediation for the nationwide cases at 8 2nd April 28 of 2015.
Landlord tenant ready for mediation with the consent of the counsel for the parties. The matter is directed to be placed for mediation. The office is directed to place this case immediately upon receipt of the mediation report. क्या डेट फिक्स करें? आप अपना मीडिएशन करा के मीडिएशन रिपोर्ट जैसे ही आएगा तुरंत लिस्ट हो जाएगा, मेंशन करेंगे तो भी लिस्ट हो जाएगा।
मीडिएशन के लिए भी यहाँ से जब डेट होता है
First date
First date.
and thereafter it will be continued. Stop.
Just a moment. As the council for with the at the request as a joint request of the learned council for the parties, the first date for mediation is fixed before Jhalsa. Before Jhalsa on बताइए कौन सा डेट हो जाएगा मैडम 16 on 16th of February 2026 at 11 a.m. It will be open to the parties to join online.
Item 10, second appeal 135 2016.
At the request of the council, let this matter be placed for mediation. और वही same order. Mediation report के बाद तुरंत list करना. Dictation. वो जो order किए ना?
वो डेट तो नहीं होगा ना
नहीं date नहीं. The office is directed to place this case immediately upon receipt of the mediation.
Item 11 second bit 249 of 2019.
सेम होगी। आप हैं इसमें? आपको करना है मीडिएशन कि नहीं करना है? इसमें लिखिए। Counsel for the parties are present. The learned counsel for the respondents has submitted that he has no instructions for mediation. He submits that accordingly this matter may not be sent for mediation. क्या matter? What is the matter? What is the substantial question of law framed? Not framed.
19.1.3. The substantial question of law that is being whether the learned first appellate could commit a perversity by not setting aside the judgment and decree passed by the tribunal against a dead person being the defendant number 5 of the suit, namely Amrit Mandal, in view of para 6 of the judgment of Honorable Supreme Court in the case of Vishnu alias
चलिए
Ram.
कल सुनते हैं. Considering the substantial question of law, the matter is directed to be posted for final disposal.
Lordship, Monday, Mr. Rahul Kumar Gupta, Monday.
Monday. At first case 10:30. इतना छोटा सा मैटर है सर, अबेटमेंट का मैटर है. ऑल ऑफ इट नहीं, आप कुछ टाइम का करिएगा. इतना छोटा सा अबेटमेंट का मैटर इतना दिन क्यों पेंडिंग रहेगा? अबेट हुआ है तो अबेट हुआ है, यू विल हैव राइट एज पर लॉ, राइट. मान लीजिए आपका फर्स्ट अपील अबेट हो गया बिकॉज ऑफ डेथ ऑफ वन और द अदर पार्टी. टू थिंग्स हैज टू बी सीन. फर्स्ट इज वेदर हिज इंटरेस्ट इज सब्सटैंशियली रिप्रेजेंटेड और नॉट, such that in order to sustain the decree. The second, if it is not so, then under such circumstances, if the judgment is a nullity, right, conflicting decree तो नहीं होना चाहिए ना. If the judgment is a nullity, then the concerned party will have to have a right to reopen the decree as per law. इसके लिए क्यों पेंडिंग रहेगा यहाँ? ये सब कोई मेरिट में डिसाइड ही नहीं होना है इसमें. और अगर मान लीजिए कि अबेट नहीं हुआ है and the interest was substantially represented, then we will decide the appeal. अभी तो इतना ही है सिर्फ, इसके अलावा कुछ है ही नहीं इसमें. Only one substantial question of law has been framed. अब देखिए लोग कुछ एडिशनल करेंगे. अब देखिए इतना आसान मत समझिए, कुछ तो करेंगे.
एक सप्ताह के बाद
अच्छा ठीक है, एक हफ्ता के बाद. कब चाहिए बताइए? नेक्स्ट थर्सडे. नेक्स्ट थर्सडे फर्स्ट केस. क्योंकि देखिए आई टेल यू वन थिंग, मैकेनिकली हम अवेटमेंट का ऑर्डर नहीं पास करेंगे. एंड आई विल हैव टू एग्जामिन, देयर इज अ रीसेंट जजमेंट ऑफ द ऑनरेबल सुप्रीम कोर्ट दैट वी हैव टू एग्जामिन एज टू वेदर देयर इज अ लाइक्लीहुड ऑफ अ कॉन्फ्लिक्टिंग डिक्री. इफ देयर इज नो लाइक्लीहुड ऑफ अ कॉन्फ्लिक्टिंग डिक्री एंड द इंटरेस्ट इज सब्सटैंशियली रिप्रेजेंटेड, देन आई विल नॉट पास एन ऑर्डर. merely because a person is dead, automatic abatement ऐसा नहीं होगा.
Item 12 second page.
सर ठीक बोल रहे हैं ना? बताइए आप. जस्ट हाँ, इतना पुराना 1973 का सूट, एक आदमी मर गया तो पूरा कहानी खत्म तो नहीं कर सकते ना. हाँ, we have to see the party position, the nature of relief, everything is required to be seen. So mechanically नहीं करेंगे.
Item 12 second page 289 of 2019.
Set for mediation? Yes. क्या मैटर है? डेट फिक्स कर दे मीडिएशन के लिए. 16th. With the consent of the parties, this matter is sent for mediation. The parties have agreed to participate for mediation on 16th of February before Jhalsa at 11 a.m. It will be open to the parties to join the mediation online. एक चीज ध्यान दीजिएगा, जहाँ से भी आप लोग ज्वाइन करें, एक बार तो यहाँ आना पड़ेगा. This is one thing. Secondly, it's better if you join through DLSA because somebody has to be there to identify you. पता चले कोई fictitious आदमी mediation करके चला गया. And ultimately you will have to come and sign the document over here. ठीक है? To make sure that this is followed. Otherwise, compromise अगर होगा भी तो void हो जाएगा. Office is directed to place this case immediately upon receipt of the mediation report.
From day list for mediation for the nation drive, item 40, second appeal 404 of 2016.
Yes, who is for the? Government is not interested in mediation. They want decision on merit in every case. कौन है इसमें counsel? The matter has been called out so that it could be sent for mediation. However, the appellant is not present. Pose this case on February 11th. Let a copy of this order be forwarded to the Office of Learned Advocate General to ensure that the appellant is represented on the next date.
Item 41, second appeal 434 of 2017.
ये क्या है? मीडिएशन के लिए? Not possible.
सादा adoption date is under
अच्छा,
challenge.
सादा adoption.
Adoption date is under challenge. Suit much for declaration of right act.
It is compulsorily registrable.
Yes, it should be registrable. Adoption date.
There can be an adoption if the ceremonies are performed.
But it has not been approved by it has
The
not been
ceremonies have not been proved.
and it has not been considered by the first appellate court itself. So the appeal has been allowed by the first appellate.
Yes.
We have the purchase.
This is a unlisted adoption date, whether this is valid or not. This is the only question of law.
Is it compulsorily registrable?
But also it has to be proved by the.
We are not bothered about it. आप जैसा substantial question of law बनवाए हैं वैसा ही आंसर मिलेगा. ध्यान नहीं देते हैं.
We are the purchaser, my lord. We are the
जब
purchaser.
substantial question of law बनता है ना तो ध्यान नहीं देते हैं कि कहाँ से कहाँ आपका आंसर मिलेगा.
The purchaser of the suit and subsequently the defendant has claimed that
ये तो छोटा सा पॉइंट है सर. बताइए कब करिए? मीडिएशन तो पॉसिबल नहीं. 23rd का वीक में रखें. चलिए देखिए. सेकेंड अपील नंबर 434 of 2017. The counsel for the appellant submits that the appellant is not ready for mediation. Considering the short question of substantial question of law formulated by this court by order 85/2021, the learned counsel for the parties have jointly submitted that the matter will be placed for final disposal on 25th February. Right?
Yes, sir.
Holds this case for final disposal on 25th February in the supplementary cause list to be taken up as first case. Parties to prepare short synopsis
Yes.
for assistance and also place the judgments which is to rely upon prior to the next day. एक दिन पहले भी आ जाएगा,
Yes.
लेकिन जजमेंट लिखाने में आसान हो जाता
जी।
है, नहीं तो यू नो जिस सेकेंड अपील में तो फर्स्ट अपील से कहानी प्लेन से कहानी शुरू होती है.
My senior will assist.
Who will assist? Who is
My
assisting?
senior.
Who?
He will be assist.
Who will assist?
Mr. Vijay Prakash.
Oh,
Yes.
so compulsorily registrable है adoption deed.
वो पार्टी को contact किया है, पता नहीं
Contact कर देते हैं.
ना
Compulsorily registrable नहीं है sir. As
इनको कल एक चांस दे दिया जाए पार्टी को contact
ठीक है वो हम दे ही दिए हैं, ऑलरेडी डेट फिक्स की.
All right.
Item 42, second appeal 441 of 2017.
इसको केस नहीं डिसाइड करना है ना.
Respondents are not agree.
नहीं बंद हो गया कहानी खत्म. अब क्वेश्चन ऑफ लॉ आपका डिस्पोजल हो जाए. बताइए ना आपका बताइए क्या सब्सटेंशियल क्वेश्चन ऑफ लॉ क्लेम करा.
20 एक 2020 को 200 एडमिट हुआ था
बस ऑर्डर 41 रूल 31
और जो कि
रिवर्सल है कि कॉन्करेंस.
नहीं.
रिवर्सल है और इसमें जो है सो पॉइंट ऑफ डिटरमिनेशन ऑलरेडी करके जो है सो एप्लेट कोर्ट जो है सो इसमें किया था.
चलिए आपको तो ये तो आप मास्टरी है आपको इसमें क्या दिक्कत.
41
हम देखते हैं यहाँ हर एक सेकेंड अपील में ये सब्सटेंशियल क्वेश्चन ऑफ लॉ प्रपोज जरूर रहता है. बताइए.
Compliance नहीं होता, demand होता है.
नहीं ऑलरेडी कंप्लाइड
देखिए बताइए.
तो डिस्मिस हो जाएगा.
हाँ बताइए
तो एक डेट फिक्स से आज
डेट बताइए कौन सा शुभ दिन निकल.
शुभ दिन 2 सप्ताह के बाद.
25 तारीख
हाँ.
एक 25 को फिक्स किया ना अभी. मंगलवार बहुत शुभ दिन है, 24 तारीख को कर देते
हाँ
हैं.
बिल्कुल.
ठीक 25 को एक ऑलरेडी फिक्स कर.
जी.
Second appeal number 441 of 2017. The respondent is not ready for mediation. Full stop.
सिर्फ पॉइंट
Considering the
माइंड करने से नहीं होता, उसमें वापस बात करें
कोई बात आपको सुन के ही डिसाइड.
हाँ.
मेरा दो तीन जजमेंट है.
एक अक्टूबर में लायन महदी साहब आज लायन.
अच्छा. Considering the short point involved in this case, framed by order dated 29th of January 2020, and with the consent of the learned counsel for the parties, post this case for final disposal on 24th of February 2026 to be taken up at first case at 10:30. Supplementary list में डालेंगे. एक ध्यान रखेंगे ये जो डेट फिक्स कर रहे हैं ना ये इस वीक में, इसमें कुछ भी डेट फिक्स करने के पहले सोचना होगा कोई भी केस का. ठीक है, ऐसे डेट फिक्स करने से तो कोई फायदा नहीं है. और जिन केसेस में इंटरिम ऑर्डर है और एक्सपायर कर रहा है हम एक्सटेंड नहीं करेंगे, हम सुनेंगे. दिस इज आई एम जस्ट टेलिंग यू. कल 2-3 में आपका किया. हाँ बस आप तैयार ही रहिए.
Item 43, second appeal
मैकेनिकली या इंटरिम ऑर्डर
462
एक्सटेंड नहीं होने वाला.
Item 43,
यस मीडिएशन. क्या हो गया मेडिकल इमरजेंसी. रोहित सिंह मिस्टर नीरज राय, किसकी तबीयत खराब है? रोहित जी के बेटा की तबीयत खराब, कब रख दे बताइए? Post on next Thursday.
Item 44, second is the 61 of 2025.
Specific performance period. Neither the special period, the plaintiff has not been examined. At point period, the suit has been dismissed. And the period, his son has been examined because he was at advanced stage.
आप बताएं, can it be sent for mediation?
Yes. Already paid some amount.
We have paid out of 20 lakhs, we have paid 10 lakhs. 50% of the amount has already been paid, and that is been admitted by the parties. Only for the reason that the plaintiff has not been examined, the suit has been dismissed.
But the substantial question of law is something else, completely different.
Not the first option.
Oh, first, okay. Non-examination. With the consent of the learned counsel for the parties, the matter is sent for mediation. The counsel for the parties have jointly submitted that their party shall appear before Jalsa for mediation on 16th of February.
Jalsa और legal service के लिए हाईकोर्ट
कहाँ पे जाते हैं?
जब दोनों जगह होता है, तो हाईकोर्ट में जाता है।
Jalsa है basic. On 16th of February, it will be at 11 a.m. It will be open to them to join the mediation online.
I just suggest that if you go in हाईकोर्ट legal service का नीचे कहीं तो अलग सोर्स में if they want some assistance that we can.
हमको लगता है ये मीडिएशन ड्राइव झालसा में जाना, ठीक है? अब वहाँ पे एक्सपर्ट मीडिएटर्स भी हैं, ये जितने भी ऑर्डर्स हो रहे हैं ना मीडिएशन में भेजने के लिए, let this order be communicated to the secretary Jhalsa to ensure that an appropriate mediator is appointed for the purposes of mediation. Yes. Yes. Okay. The office is directed to place this case immediately upon receipt of the mediation.
From supplementary list of items for item 1, second page 88 of 1984.
ये जरा इसका रिकॉर्ड देंगे. Let us have a look at the partition deed. It's a registered partition deed. Okay, even if you say that they are, you see, uterine blood relation, but they constitute a joint family. In spite of this, they are a part of joint family.
Yes.
Maybe that they do not form a part of co-personal for the purposes of transfer of property by inheritance or survivorship, but certainly they form a part of the joint family.
But it's the findings of the fact of the Appellate court below that they are not the title holder. The finding of fact that has been not reversed by the Appellate court below. Therefore, in this point, matter it is actually concurrent finding that they are not.
We'll see that. I just wanted to share that they certainly form a part of the joint family, correct?
But not entitled for sale.
That is a separate thing. But they form a part of the joint family at least. This you cannot deny. Right? That status you cannot deny. Let us see the partition deed.
Partition deed to minor mother of the plaintiff has executed. in which, my lord, half share has been given to plaintiff and half share has been given to her two children born from the previous husband.
Where is that?
It is also not equal, my lord.
Where is that? Exhibit number.
पढ़ने लायक नहीं है।
नहीं कोई बात नहीं, हम पढ़ लेंगे, आप एग्जिबिट बताइए।
H.
H. This is partition deed is exhibit H है? H. What is the date?
1946.
1946. Who are the parties to this partition deed?
A mother of the plaintiff and the other two sons. That time my plaintiff was minor.
What was the age?
Yes, that has not been mentioned, but only mentioned the minor.
No, age should be not because in 1950 the plaintiff has obtained majority. So 1946 4 years, now 14 years.
Exact age has not been
Maybe.
कोई 50 में
अब एक सेंचुरी पहले का बात कर रहे हैं तो हम लोग ईयर ही बताएंगे ना, एग्जैक्ट डेट ऑफ बर्थ तो नहीं पता चलेगा। 1950 प्लेंटिफ
at age of majority.
the other two persons, there are
Major.
are major. They are the natural sons of the mother from first.
Previous.
Okay. Now you tell us, mother of the plaintiff from second husband.
Second.
They are Hindus.
Yes.
When did the husband die?
Husband died 1949.
1949.
49
49 कैसे हो?
49 के पहले
46 के पहले.
हाँ 46 के पहले
हाँ.
पार्टीशन
Yes. Anyway, certainly prior to 1946.
42. In our para 4 of the
1940.
42, that Ganesh Madhu died sometimes in the year 1942.
It was his self-acquired property or it was his ancestral property?
सेल्फ एक्वायर्ड या नहीं, property belongs to the Ganesh Mahato as per the
ओके तो his exclusive property कोई ancestral property से डिवॉल्व कर रहा है ऐसा कहानी तो नहीं है.
इसमें नहीं लिखा हुआ।
Exclusive property of father. Okay. Now after the death of father, the widow is there and 3 children are there.
Widow has not taken any share.
No, she might not have taken any share, but she is entitled to her share. She is dealing with her share also. Isn't it? She is dealing with her share also.
But he has not, she has not taken.
But she is already a co-owner of the
Yes,
property.
yes, yes.
There is no doubt on that. What share does she take in property? How much share does she take in her property? If she takes 50% share and out of this property, she gave 50 to the natural, to the legal years of her first husband or children born out of her first husband.
There is a difference, madam. If she
No,
has,
what I am trying to think is as to whether, apart from the fact that this deed has not been challenged, what I am trying
yes,
to
yes, my lord. There is a rule, my lord. If it is self-acquired property of the female, then distribution is different.
It is
if
not the
it is
self-acquired
from,
property
If
of-
she got from the husband, then it should be disputed to the legal years of husband.
Okay, legal years, there are 2 legal years.
Only one.
2 legal years. One is the mother, the widow.
Then after death.
Yes, after death of the husband.
My lord, after death of Nirsi, Nirsi's property will be
No,
devolved
no,
upon.
no. You see, during the lifetime,
Yes.
the widow has dealt with the property in a particular manner. Right? She
Yes.
has dealt with the property in a particular manner. Right? She is the owner of the property to some extent. The percentage we have yet to see. According to you, at best, the property will devolve upon the widow and 1 son. Widow and 1 son. So 1 son cannot claim the entire property.
Kindly may be pardoned. This, as per the partition suit, a partition deed has been executed in 1946. As per the plaintiff, it is a paperwork. They have done nothing, my lord. They have kept the partition deed in the box. It has been in evidence, my lord. And only in the 1973, that is after death of their mother, they have executed
We
the
are
same deed.
only concerned with the fact as to whether this deed was required to be challenged or not.
Yes.
And
yes,
if challenged,
yes.
whether it was challenged within the period of limitation.
During lifetime of the mother, our son has no right over the property. During lifetime of the mother, यदि माँ यदि सेल करते तो अलग बात है, माँ सेल नहीं की, तो माँ जिंदा रहते भी उनका बेटा को नहीं जाएगा। तो शेयर, माँ का शेयर मिल रहा है माँ का डेथ के बाद, तो माँ जब डेथ कर जा रहे हैं उस समय जो फीमेल पर्सन का जो रूल है प्रॉपर्टी, सेल्फ एक्वायर्ड प्रॉपर्टी का और हस्बैंड से मिला हुआ प्रॉपर्टी का रूल अलग है। तो डेथ के बाद का ये क्वेश्चन है कि लड़का को, उनका लड़का तो मिलेगा कि नहीं, उनका डेथ के बाद ये क्वेश्चन अराइज कर रहा है, तो उसमें नहीं मिलेगा।
During her lifetime, she can't do
कुछ
anything.
नहीं
She can't do anything with the property.
कर सकते थे लेकिन मैंने किए कुछ नहीं। ठीक है, उसमें भी यदि पार्टीशन करते तो उनका तीनों लड़का को मैं पार्टीशन अपना से, वो भी कुछ नहीं।
Okay, this is your case.
Now, my lord, thereafter, my lord, kindly see the para.
No, I will just see the trial court and then the appellate court judgment.
That's
सही जब ये जब rather I always see right from the plate. Plate.
Plate sir. Plate.
Para 2.
One Nirsi Devi was married to Uttam Mahato of village Inga of Uri at a very early age, and she had not even Nirsi Devi got 2 sons from Uttam Mahato, Buddhan Mahato and Nandan Mahato at a very early age. Soon after the birth of the second son, Uttam Mahato died, leaving his children sometime after service. That Ganesh Mahato thereafter married Nirsi in or about the year 1928, and when Nirsi came to the house of her new husband, Ganesh Mahato, she brought her 2 children, Buddhan Mahato and Nandan Mahato, who are in the council of Ganesh Mahato, and brought them up. In course of time, Nirsi devoted Mahato and small daughter to Ganesh Mahato, namely the Vendi and Kumari India. Julia in course of time was married to Ladu Mahato, and she is still living with her husband and children. That Ganesh Mahato died sometime in the year 1942, leaving behind his widow Nirsi and his daughter Julia and his son Bhakti Mahato, have been succeeded to the lands of Kasan Golden of village.
Daughter was also there.
Yes. That after the death of Ganesh Mahato, Nirsi began to prescribed by Defender number 1 and 2 to give them some lands for their maintenance. They fear that Bhakti Mahato or that terms of faith do not allow them to share and none of the land out of their below and she also has some short terms in her heart for her husband and sons. Therefore, they see without being right or in law to do so is taking the silver partisan among Bhakti Mahato, Appellate and Buddhan in Maya Defect number 1 on 29/146, acting as guardian of the minor 20 and that attempt knowing full well that Defect number 1 and 2 had no right or title in the lands of Appellate nor would they have demanded partisan. They see purported to adopt 8 Anna share jointly to Defect number 1 and 2 and 8 Anna share to the plaintiff, making it false. Despite that, such a arrangement had been made by Ganesh Mahato himself during his lifetime, but through the document dated 29/146, the mediator has agreed to a partisan who did not partake of the nature of partisan but simply purported to define the share of plaintiff as number 1 and 2. However, this was a mere paper conviction and which did not become operative, nor could bind the plaintiff, who was a minor at that time and had no knowledge or idea about such a document, which was made from a close defect number 1. I think also it never dismisses this fact, even though relative more to the person in the village. When he has stated that in the world, they claim they love it in the hands of the member, beginning with the year 1970. That the plaintiff had been married in the year 1952, before which he had died in the year 1949. The plaintiff, after getting married from the related one and two living in separate house, the plaintiff would come to know matter from the villagers about the quality of the plaintiff number 1 and 2. However, after getting married, the plaintiff entered into fast cultivating possession of all the lands of the plaintiff and after the date of vesting the plaintiffs, the father's time was over, and continued in the appearance later prepared and appealed by the state of the plaintiff on receiving the demand, which started paying rent for the entire 11.4 acres of land of the and continued to pay rent in 1964. The plaintiff also remained in fast cultivating possession of 11.4 acres of land
object mediation, while seeing lines in under pressure and into the possibility that if formally joined depending on what we are certificate they have no right title interest or possession.
What is this deed?
Deed.
Now, first there is a partition deed. Now, what is this deed in para 7?
इसमें दूसरा कहो
A and B.
इसमें चैलेंज नहीं है, इस सूट में चैलेंज नहीं है।
So now the property has been subsequently your act.
ये दूसरा प्रॉपर्टी का मतलब एक पोर्शन ऑफ प्रॉपर्टी में से।
This is not related to this.
इस सूट से रिलेटेड
Same खाता number.
सब कुछ सेम।
The partition deed was acted upon by virtue of this. 66 there were two sale deeds, that is exhibit A and B. They have executed two sale deeds in which the plaintiff and defendant number 1 and 2 jointly executed and transferred the property to defendant number 6 to 9. So not partition deed.
Which property? The property involved in this case?
Yes, खाता 11.
सूट प्रॉपर्टी नहीं है।
सूट प्रॉपर्टी नहीं है, लेकिन पार्टीशन सूट का तो प्रॉपर्टी है ना।
हाँ.
पार्टीशन में जो प्रॉपर्टी इन्वॉल्व है वो प्रॉपर्टी है ना। Is it a property involved in the partition? Yes or no?
Yes.
नहीं फुल माने उसका बिल का शेयर है
The share नहीं.
Is it
पार्टीशन डीड का उल्लेख नहीं है उसमें।
partition deed में this property is not involved?
ये पूरा टोटल प्रॉपर्टी के अंदर आ रहा है, लेकिन पार्टीशन के बेसिस पे या पार्टीशन का लेके नहीं सेल हुआ है।
वो नहीं बोल रहे हैं।
टोटल प्रॉपर्टी का अंदर में आ रहा है 11.4 एकड़ जो है उसके अंदर का प्रॉपर्टी है, लेकिन पार्टीशन के बेसिस पे सेल नहीं हुआ।
Partition involves 11.4 acres.
हाँ, उसमें उसके अंदर ही
उसके अंदर ही नहीं. हाँ.
लेकिन पार्टीशन डीड का उल्लेख उसमें है भी नहीं, और उसका किसका शेयर बेचा गया, डिपेंडेंट नंबर 1 2 का बेचा गया या प्लेंटिफ का बेचा गया और उसके and then by reading from 8 para 8 that the plaintiff had been in peaceful continuous possession of a land of Kata number 11 apostate means circulating defendant number 3 falsely instituted a criminal case against the plaintiff alleging theft of number 976 and 976 or Kata number 11. The plaintiff in course of the same case came to know that defendant number 3 who is a veteran litigant and land grabber fraudulently considered by section of defendant number 1 had no right or title to the lands of Kata number 11 obtained his sale in respect of 0.46 acres of land in block number 976, 977, 1480, 1462 on 21/2/73 without paying them a single parting in the consideration of parting out the litigation for them and for establishing their right, the plaintiff now of the said case which ended in distinct the learning president in on the ground that the compliment Appellate had instituted that case in order to secure possession of the disputed land. In that very case, the plaintiff also learned about the fraudulent and coercive partition was that there are number 1 2 3 remain while in 1963 again succeeded in setting down.
So during the execution of this 1973 deed, you came to know about the partition deed for the first time.
Yes.
And that challenge to the sale deed dated 1973
In 80,
is held to be barred by limitation.
1980 में चला
1980 में challenge किए, but that challenge to this deed has been held to be barred by limitation.
landed by landed appellate below, and landed trial court says that it is as per article 65 it is within time limit, and landed appellate court below has given finding that one of the claim, that is declaration of sale deed as void, is barred by limitation, not other. Only whole
That's
suit
right.
has not been.
That's right.
But as per the Honorable Supreme Court, my lord,
No, वो तो question of law ही नहीं है.
नहीं उसी में आ रहा है, उसी में देखा जाए माय लॉर्ड। इसमें हम एक बार हमको खाली 100 सेक्शन 100 को पढ़ने दिया, एक बार खाली इसमें फ्रेम करने का जरूरत नहीं है माय लॉर्ड, एक बार देखिए इसमें लिखा हुआ है, एक बार लैंग्वेज हमको पढ़ते हैं।
नहीं, आप जो ये सबमिशन कर रहे हैं किस सब्सटेंशियल क्वेश्चन ऑफ लॉ?
नहीं उसी को जरूरत नहीं है, उसी को हम देख रहे हैं माय लॉर्ड। एक बार खाली को एक बार एक प्रोवाइडेड पोर्शन का हमको पढ़ने दिया, एक बार हम खाली मेरा सैटिस्फैक्शन
आप अपना सेटिस्फैक्शन के लिए मत पढ़िए भाई, इस तरह से
एक बार लॉ पढ़ एक बार थोड़ा सा
सीपीसी पढ़ें।
सीपीसी में 100 हम प्रोवाइडेड क्वेश्चन
आप फिर सब्सटेंशियल क्वेश्चन
नहीं नहीं कर रहे हैं मान लो एक बार देख लिया जाए उसको
हमको पता है ना, रोज ही 100 पढ़ रहे हैं आप।
नहीं हम
कि the court can
एक को बात को हम दिखा रहे हैं।
अरे भाई द कोर्ट कैन फ्रेम एनी इशू।
नहीं फ्रेम करने का नहीं बोल रहे हैं, उस वही चीज हम पढ़ने को बोल रहे हैं। बोल रहे हैं कि बिना फ्रेम करके भी माने डिसाइड कर सकते हैं, फ्रेम जो नहीं किया गया है उसी को हम पढ़ रहे हैं। एक बार हमको लैंग्वेज provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear or decide to be repeated the appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question. Therefore, even my lord, it has not been formulated. Even then, my lord has power to decide that substantial question.
देखिए आपका ये सबमिशन करके अगर हम कोई जजमेंट कर देंगे ना तो 1 मिनट में हो जाएगा। जब तक एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम होता है, एट द टाइम ऑफ एडमिशन एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ इज टू बी फ्रेम्ड बाय हियरिंग द अपीलेंट ओनली, रेस्पोंडेंट हैज नो रोल टू प्ले। And once the substantial question of law is framed, the respondent has got a right to say that this is not the substantial question of law involved in this case. And at the time of hearing, the question of framing substantial question of law arises only when the respondent is given a due opportunity to respond to the substantial question of law. An additional substantial question of law can be addressed only if it is formulated. आपका ये oral submission हम देख, अच्छा बस ठीक है ना,
तो इसमें एक जजमेंट जो कि उसको पढ़ देते हैं।
नहीं उसमें कुछ पढ़ने का कोई
जजमेंट तो पढ़ ले, उसमें क्लियर कर दिया हुआ है कि प्राइमरी रिलीफ के बेसिस में सूट का लिमिटेशन नहीं होगा। यहाँ पर प्राइमरी रिलीफ था कि फॉर confirmation possession and recovery of possession, and it is the finding of the landed court below us that suit is not barred by limitation, only the first relief is barred by limitation. पहले सीधा मतलब एक बार जजमेंट हो गया हम दिखा देते हैं पैराग्राफ सब। अभी माइलर परमिट करेंगे,
हमारा क्या परमिशन का बात है, लॉ नहीं परमिट करता है।
लॉ तो सुप्रीम कोर्ट का लॉ सामने है माइलर, इसको माइलर टू नॉट टेक
कौन सुप्रीम कोर्ट का लॉ सामने है? आप हमको लॉ ये बताइए कि दैट आई कैन डिसाइड अ पॉइंट व्हिच इज बियॉन्ड फॉर्मुलेशन ऑफ सब्सटेंशियल।
उसमें तो माइलर इसमें दोनों पॉइंट मेरा फेवर में है एज पर माय सबमिशन। केवल उस पॉइंट को हम दिखा देते हैं कि उसमें उस पॉइंट के लिए 65 अप्लाई करेगा माइलर, कोई खाली वही हम दिखाना चाहते हैं। इसमें डायरेक्ट जजमेंट है माइलर, उसी को हम दिए हैं जजमेंट जो कल दिए हैं, लेकिन मैंने पैराग्राफ में
ना तो आपको प्रोसीडिंग पता है, ना आपको पता है कि अपने क्लाइंट को कैसे डिफेंड करना है, आपको कुछ नहीं पता। इतना दिन से एक तो आईए नहीं फाइल कर सके फॉर फ्रेमिंग एन एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ, और इतना बहस कर रहे हैं। The Supreme Court has clearly said that the court will not travel beyond the substantial question of law which has already been framed in second appeal.
My humble submission means, my lord, every court is bound by the CPC, and CPC clearly says, my
तो
lord,
अब आपके लिए कुछ बचेगा ना सुप्रीम कोर्ट पे बहस करने के लिए इस पॉइंट पर?
CPC का लैंग्वेज हम इंटरप्रेट
नहीं, बस ठीक है, एक ही चीज को बार बार मत बोलना। चलिए।
Then my lord, I have for
Okay, this is the now 76 was also barred by limitation.
Suit is of 80.
Suit is of 80. Now let us see the judgment. जजमेंट में देखते हैं, अगर कुछ ऐसा कुछ स्ट्राइकिंग होगा तब देखेंगे, अदरवाइज आई एम नॉट गोइंग टू फ्रेम एनी सब्सटेंशियल। बिना एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम किए आपका ये लिमिटेशन नहीं डिसाइड कर सकते। नहीं, आप अपना पहले तो ये आपका जो बना है उसको एड्रेस करिए एंड देन वी विल सी।
उसमें तो दोनों सब्सटेंशियल क्वेश्चन ऑफ लॉ में आ रहे हैं, कुछ नहीं।
अच्छा, आप इम्प्यून जजमेंट नहीं प्लेस करेंगे?
नहीं, उसमें तो वही चीज है, उसमें मैंने 2 पॉइंट है, एक पॉइंट माइलर बोल रहे थे नहीं सुनेंगे, और दूसरा है एडवांस पोजीशन।
ऐसा
एडवांस पोजीशन में तो माइलर आ गया है कि लोग खाली दिया है कि सूट इज बार्ड बाय एडवांस पोजीशन, नो अदर स्टेटमेंट हैज बीन गिवन माइलर। एंड अनदर थिंग माइलर कि सूट वन ऑफ द क्लेम इज बार्ड बाय लिमिटेशन। So on the basis of advanced possession minor, I have already argued one on the point of advanced possession. इसको हम पढ़ देते हैं please. Actually, लैबनेट ट्रायल को लिमिटेशन और एडवांस पोजीशन को एक ही साथ लिखते हैं। और एक ही पॉइंट में अपीलेट कोर्ट में भी फर्स्ट में लिमिटेशन पर ये है, फिर उसी में एडवांस पोजीशन को दिया है। पैरा 7 से अपीलेट कोर्ट का जजमेंट है, स्टार्टिंग ही है लिमिटेशन।
These deeds, जो 73 and 76 का जो deeds है,
Yes.
they are party to this.
Uh,
They are co-executant of the same deed.
70 no. This by defend number 1 and 2.
Defend number 1 and 2 in favor of.
In favor of notes 3. Defend number 3.
Let us see the finding of the learned first appellate court on the limitation. First appellate court on.
But this is paragraph 7. It should be internal page 7 of the first of it.
Appellate court करेगा. Seven.
Yes. Paragraph 7, internal page 7. Findings.
Yes.
Please. So far the point of limitation is confirmed. The report below have read that Article 59 of the Limitation Act is not applicable in this case, and the suit would be governed by Article 65 of the Limitation Act. So far as the applicability of Article 59 is concerned, I agree with the report below that Article 59 is not applicable in the present case because that article prescribes limitation of 3 years for cancellation or setting aside an instrument or a decree or for rejection of a contract. From the perusal of the relief in the plate, I find no such prayer for cancellation of the said deed DT.02.02.2026 and 7576. But there is clear prayer for declaration that the two two sale deeds are illegal and void, and for mere declaration regarding a document, in my opinion, Article 58 of the new Limitation Act will apply, in which the period of limitation is 3 years, has been prescribed from the time when the right to sue first accrues. Therefore, the right to get such declaration arose immediately after execution of the two sale deeds, that is Exhibit C and C by 1 of the year 1973 and 76. Thus, so for declaration of the two sale deeds are concerned, in my opinion, the claim of the plaintiff is time barred and led by law of limitation. As the suit has been filed after 3 years from the and
From the execution of the deed.
execution of the deed, and Article 65 will apply so far as the demand of recovery of possession or confirmation of possession is concerned, and for that 12 years limitation is prescribed. But in the present case, I would like to discuss the case of the defendant that the suit is barred by law of limitation on account of adverse possession of the defendant. Then what the court goes on to adverse possession. So first point that the suit is barred by limitation, Article 58 has been considered. It has been held that 58 prescribes 3 years. It is barred by limitation and no question of law has been formulated on that.
59 would not apply.
59 would not apply because it is for cancellation.
Yes.
But for a declaration that it is not binding, 58 will apply. So that also prescribes 3 years limitation.
Limitation. And you have seen the judgment he is citing.
No, but it is not.
That is the latest judgment of the Supreme Court.
Article 58 and Note 60, both have been taken into consideration.
60 is with respect to
60 is with respect to Batwala.
Batwala.
46.
That is a
So that is
separate.
one of the question of law.
That is another thing.
Yes.
58 is to obtain any
To obtain
declaration.
any other declaration.
The appellate court says that yes, it is not a suit for setting aside the sale.
Yes.
And then the court says that it will be governed by
Article 58.
Article 58. Now, the trial court has held that
But the trial court holds that it is for possession. So therefore Article 65 will apply. But not possession of what? Not of the property which have been is a subject matter for sale deed.
That's
So
right.
unless and until that sale deed is declared to be null and void, not binding on the plaintiff, how can the possession be handed over then? So the first relief is definitely primary relief is declaration of a sale deed.
So you want to say that any suit cannot be decided solely on the basis of section 65?
But if he is already in possession, then definitely if I say that irrespective of the sale deed, I am in possession and just I want a confirmation of my possession.
No, not necessarily, because you see, suppose a person is in possession
Yes.
and 12 years has not expired
Yes.
from the date of his possession. Then the real owner can certainly sue him for recovery of possession within 12 years. Once 12 years expires,
Yes.
then the some cause for holding that the adverse possession has matured can happen. But if a person is in possession by virtue of a deed executed by a person who did not have the right to execute the deed, or maybe that he is not even challenging the deed and saying that it is void and it is not binding on me, I am not a party to it, then under such circumstances can he still file an application for recovery of possession without challenge. You see, the appellate court has held that it is not hit by sections 58.
No, it says hit by 58, not by 59.
No, it says it is hit by
58.
58, not by 59.
Yes,
59 is for cancellation
59
because
is
they are
for
not
cancellation.
seeking any
Yes, prayer for
cancellation.
cancellation. Yes.
No prayer for
No prayer
cancellation.
for cancellation.
Right? Now, this declaration
Yes.
that the sale deed is void.
Don't we see from this angle? That
You just have a look at this
Yes.
25 judgment. पैरा 31 देखिए.
yes, plain single. This was the case. I
You
argued
read
for
para
document
30
one.
also. You read para 30
Yes,
also.
yes, yes.
You read it, please.
Yes. In the decision of this court in Hussain Ahmed Chaudhary versus Abdul Rahman, when one of us was a member of the bench, it was reiterated that a person who is not a party to an instrument would not be obliged in order to seek its cancellation. The reason being that an instrument would neither be likely to effect its title nor be binding on him. However, such a plaintiff must at least seek a declaration that the said instrument is not binding on him, or that is invalid insofar as he is concerned. The relevant observations are reproduced herein. As observed aforesaid, the plaintiff who is not a party to a decree or a document is not obliged to sue for its cancellation. This is because such an instrument would neither be likely to affect the title of the plaintiff nor binding on him. We have to our advantage two very old eluded judgment of the Madras High Court and one of Privy Council. In these
Now, this is basically a person who is not a party to the deed.
yes.
He will only seek for a
Declaration, not for cancellation.
Not for
because he was not a party to
Now come
execute
to
the deed.
para 30,
Para 30.
31.
Okay. As per dictum of Dev Singh, this court, in order to ascertain whether Article 65 of the Limitation Act 1963 would apply to the present factual scenario, has to first determine whether the fraud was alleged as regards the contents of the sale deed dated 14/6/73 or the character of such sale deed. Both the first appellate court as well as the High Court have arrived at a finding that the plaintiff had never executed the sale deed in the first place, as it was proved that it was not her thumb impression that was affixed there. Therefore, this finding goes to the character of the sale deed and thereby renders it void ab initio. Hence, as per the decision, there remains no reason for the plaintiff to seek for its cancellation. The original sale deed also does not produce before the trial court when the defendant is ordered to revert the doubt cast upon the veracity of the sale deeds. Consequently, Article 59 of the Limitation Act would find no application in the case. Here, the sale deed itself is doubtful. The execution itself is doubtful. The sale deed itself is void ab initio because the fraud has been claimed. So here, it is not a case of fraud. And you will see from this angle. Admittedly, not the property was of Ganesh. He died. So, there were two owners.
Lot of adjudication involved. Lot of adjudication involved in connection with the sale deed. It is not on the face of it void ab
Yes, it is
initio.
not.
That a situation where a person is dead and a sale deed is
Sale deed has been executed, or not. Apparently, not the person who is executing a sale deed is not present.
It
Someone else.
requires an adjudication.
Therefore, but here it is not a case. But here the Lord will see from this angle. But
ठीक है, देख लो. अब आप इनका जो existing substantial question of law है उस पे आंसर करें.
But let us see.
नहीं बनेगा आपका.
इसमें अभी permit
हम देख लिया. अब आपका
judgment को,
परमिशन नहीं इतना परमिशन हम आपको
ये
1984 से परमिशन दे.
correct law मैंने दिखा
हाँ बताइए कौन सा पैराग्राफ छूट गया?
पैराग्राफ हमको पढ़ने नहीं दिया।
बताइए कौन सा पैरा आप पढ़ना चाहते हैं? एनालिसिस से ही पढ़िएगा ना पैरा 24 से.
एनालिसिस से
पढ़िए। इतना इंसिस्ट कर रहे हैं, सोचिए एक बार देख लेंगे। इसलिए
इसमें हमारा एक ही चीज
कौन नहीं, आपका वो कमेंट्री नहीं चाहिए, आप इसमें से पढ़ के बताइए क्या बताना चाहते हैं। विच पैराग्राफ यू वांट टू रिलाई अपॉन?
पैरा 29 30 30 तो माइनर 29 38 39
29, 38,
39
28 में तो यही है।
29 में है 38 तीन पैराग्राफ। इसका जो प्रेयर है माइनर पैरा 5 से इंपॉर्टेंट है इसका सूट का जो प्रेयर सूट का प्रेयर पैरा 5
इतना नहीं पढ़ना है।
मैच करा रहे मेरे केस के साथ मैच करा रहे फैक्ट को मैच करा रहे पैरा 5 से मैच होगा इसीलिए उसके बाद उसको डिस्कस करना है।
क्या है पैराग्राफ?
Plaintiff insurance civil suit number 782 of 1984 in the court of Single subject to law for permanent injunction restraining the defendant for interfering with their peaceful possession to the extent of 1/3 share in the agriculture and administering 31 canals road and is situated within the Review state of India. Iskar upper to Tehsil district in the alternative the plaintiff prayed that they put in joint decision along with the defendant and the same is dated 14/6/73 purported to have been executed by Ram Saran son of Number and the plaintiff in favor of the defendant be declared as fraudulent, competent, thereby void insofar as the share of the plaintiff is possible. See my paragraph 29. This court in Basic versus Cable 2006 5 to discuss the position of law student Article 59 of the Mediation and 1963 will apply and remain as follows. First, that Article 59 of the Mediation will apply only recognized within this code fraudulent condition which are fraudulent condition and not those outright. In other words, Article 59 is only where an instrument is practically valid and not those instruments which are presumptively invalid. Secondly, that when the document in question is void, ab initio or valid, the decree for setting aside the same will not be necessary, since such a transaction will be nullest in the eyes of law owing to nullity. मेरा केस इसी में पड़ रहा है, सेकंड में पड़ रहा है. Thirdly, a fine distinction was drawn between fraudulent misrepresentation as regards the character of the document and the fraudulent misrepresentation as regards the contents of the document. It is only in the former situation that the instrument will be void and in the latter it will remain valid. Simply, Article 59 will not cover the documentation with respect to the void transaction. Lastly, that if a deed was executed by the when it was minor and it was void, he had two options to file a suit to get from the complaint thereafter, that is the suit either file a suit within 2 years under deed or within 3 years of attaining the element. Observation are reproduced as under Article 59 is specifically belief is that is not reasonable matter. You permitted to read that article. Check for the no question arising due to cancellation when the decree void or or setting aside the same not be necessarily as the same is not nullest in the eye of law as it would be nullity. Once however a suit is filed by a plaintiff for cancellation of penalty, it will be governed by Article 59 even if Article 59 is not attracted the residual Article 59 would attract a person under the influence of the supposition of law with the plaintiff as such will brought to the court. Article 59 would apply to the case of such instrument. It would therefore apply where the document is privacy and it would not
such and such. This okay that formula is implemented as reverse character of the employee or formula is implemented as a and the person will be defined if there is a formula is not only as per the context of the document but as per the script. Now, everything may be clear is formula is implemented as per the character of the document and formula is implemented as per the document there. Reference to the formula as the main or the condition required for the increase in in that case, if all was found to be late and it was laid at the switch was to be 15 days after that,
आप किसके लिए पढ़ रहे हैं? The appellate court has held that you are guided by say Article 59. 58. You are guided by 58. Once you are guided by 58, how can you be simultaneously guided by 59 by 65? दोनों एक्ट दोनों तो simultaneously नहीं लगेगा ना, तो फिर
38
दोनों simultaneously तो नहीं लगेगा ना, तो 58 will apply. There is no doubt on that.
38
Deep and
Contrary finding of both the past appellate court and the high court indicated the husband of the defendant, one Bhagava, who had allegedly the remaining same condition.
38 says that if there is no consideration
Yes.
paid, then it is absolutely no sale deed at all.
टाइटल जो टाइटल होल्डर है उनको एक पैसा नहीं मिला. टाइटल होल्डर इज द प्लेटिव. ठीक है 39 को पढ़ लिया जब उसने
हाँ बस पढ़ लिया.
39
चलिए पढ़ लिया अब आप बताइए.
The second question is concerned, which relates to Lord's partition. But kindly take this situation, Lord. Admittedly, Lord Ganesh Mehta was the owner. He died in 1942. So, Lord, after his death, his wife, Nilsi, and as per the plaintiff, his son, who is plaintiff here, Bhakti, they were two owners. So, Lord, Nilsi executed a partition during her lifetime. So, Lord, she was also a owner of the property, joint owner with the plaintiff. So, she would have distributed. Let me assume, Lord, she could not have distributed Lord plaintiff's share as a guardian. Let me assume this for. But she was also having some right over the property. So, she would have alienated that right by virtue of partition among defendant number 1 and 2. And on basis of that, defendant number 1 and 2 executed sale deeds in the year 73 and 76. Prior to 73-76, acting upon that Batwaranama of 1946, plaintiff and defendant number 1 and 2 jointly executed sale deeds. If they say on one hand कि Batwaranama से defendant number 1 and 2 को कुछ नहीं मिला, then there was no occasion for the plaintiff to join hands with defendant number 1 and 2 in the year 1966 for executing a sale deed to a person of same khata. So they acted upon that Batwaranama in the year 66. That is exhibit A and B. Now, so far as two sale deeds, which is 73 and 76, they say कि बंटवारानामा में डिफेंडेंट ना 1, 2 को कुछ नहीं मिला, इसीलिए वो sale deed जो है वो गलत. And now, Lord, your Lordship will see, Lord, by virtue of that बंटवारानामा, what has happened?
बंटवारानामा में डिपेंडेंट 1 and 2 को तो मिला ही.
मिला, definitely. Lord, I am saying कि निसी को admittedly तो ओनर थी, उसमें तो कोई डाउट नहीं है. So जब वो अपना शेयर अगर बंटवारा करके दे दिए अपने दोनों बेटा को from first husband, then that Batwaranama ought to have been challenged after attaining majority, that is after 1950 within 3 years.
And otherwise also निसी बाकी दोनों तो मेजर हो गए थे उसके बेटे. She dealt with her property.
हर property,
Some because she also had a share in the property.
definitely. And this is one direct judgment on that. After attaining majority, you have to challenge in 3 years. That is Article 60.
प्रेम सिंह में भी तो है.
हाँ.
And that is guided by Article 60.
60. To set aside a transfer of property made by a guardian of a ward by a ward who has attained majority 3 years when the ward attains majority. So admittedly not as per plaint itself, he attained majority in 1950. Suit is of 1980. And so far as this partition is concerned, it has never been challenged.
What is the right of a widow under 1937 Act?
So 1937 Act was the first time the widow got a right in the widow. Before that there was no right at all.
That's right.
The 1937 was the first woman's right to property Act 1937. That was the first time when widow got some right in the property of her husband or father. Before that there was no right as such. So admittedly not here unless this was done within 3 years.
And है तो Hindu Women's Right to Property Act, Widows' Right, 1937.
And was apparently after
Because you see this, his argument is, let's see, test his argument. His argument is partition is not a transfer. Partition is amongst the co-owners of the land. Now, say Article 60 is dealing with transfer. So, this clause that it has to be challenged within 3 years from the date of transfer, does it apply or it does not apply? And in the partition, the two sons also were signatory to the partition deed.
two sons, different number 1 and 2.
Were they also signatory or she just allocated it to them?
That we have to check with the exhibit H. Okay.
देखिए तो जरा इससे क्या पता चल रहा है, who are the signatories to this partition deed? देखिए जरा इसको, ये है।
But they are signatories.
They are signatories. Right.
So So it is basically not allotting Lindsay's share to her two sons, born from her first husband. If according to the plaintiff, the defendant number 1 and 2 were not the owners for share of the property of Ganesh, then what Lindsay was admittedly one of the co-sharers. She allotted her share to Mangal, defendant number 1 and 2 by virtue of this 46. But this transfer of Nilsi's interest in favor of
Is
defendant number 1 and 2.
entitled to, with respect to the property in respect of which he lies intestate, to the same share as a son. मतलब equal share as
Equal
a son.
share.
बराबर बेटा जितना बराबर हक.
बराबर share. And therefore, if she was having not half share of 11 point some, at least 5 point something.
So at
Yes.
best, the plaintiff was having half share of the
Yes,
property,
no doubt.
which he retained.
Which he retained.
And what has gone away is the share of the widow
Widow.
by virtue of the partition.
Yes. And that is not because आठ आना दोनों को 50-50 किए हैं. खाता 11 का है 11 point something. तो 5 point something जो है वो इसको दिए 5 point something plaintiff को दिए. So therefore, your lordship receive at best transferred her interest in favor of defendant number 1 and 2
Through the partition.
to partition. Because admittedly defendant number 1 and 2 were sons of Nisi. There is no doubt on this.
She had given up her right.
Given up her right is
These people,
yes.
all of them were certainly part of the joint human family.
Yes.
There cannot be any doubt. They are not alien to the family.
Yes.
Right? They come in the
The
family.
same mother.
Same mother, and they certainly come in the family.
Yes. And not once the suit is read by limitation article 58, then not everything falls.
Only a part of the suit.
Yes.
Only a part of the challenge to the sale deed.
So therefore, what is the
The entire property was alienated by 73 and 76 sale deed?
No.
No.
It was only part, and
Only
that
a
is the suit property. So once not the challenge to sale deed phase by virtue of limitation, the second relief, which is only schedule of the suit property, it is not the entire property. The lordship will see the plain, जो सेल डीड का शेड्यूल है उसी का ये रिकवरी मांगा कंफर्मेशन और रिकवरी उसी प्रॉपर्टी का है ये नहीं कि मेरा जो 5 point something
उसका 50%
नहीं
मांगा
ये खाली सेल डीड का मांगा
because they are already a party in that alienation.
alienation
कई सारे alienation हो चुके हैं.
so therefore he is only seeking recovery with respect to the sale deed portion property that is 1.23 acres only not a 5 so therefore once the challenge to sale deed will fail definitely not the second relief which is ancillary to that will definitely go.
Section
I am arguing this because I am a dependent who is very safe in this because my sale deed is not under challenge. There is no relief as against my clients. The relief is against defendant number 3 whom I am not guaranteeing. But I am here not to assume whatever is the
And by this the plaintiff is seeking declaration of his title with respect to which properties? The entire property related to Batwaranama, or he is seeking title with respect to only sale deed?
only sale deed.
So technically you are not challenging the Batwaranama.
whole property में मेरा केस
But that is not your case.
मेरा केस वही है
That is not
प्रॉपर्टी में हम है
that is not the relief.
नहीं तो रिलीफ क्या मांगेंगे हम जिसमें कब्जा में हम क्या मांगेंगे टोटल प्रॉपर्टी मेरा और इनका जो लॉ पॉइंट वो दिखाया वो सही नहीं है मतलब सेक्शन 15 देख लिया सक्सेशन एक्ट इसमें वो एकदम सीधा बोला गया है कि जो विडो है उसका शेयर कैसे डिवॉल्व होगा
शेयर मरने के बाद ना?
नहीं मरने का जो चीज मरने के बाद होगा वो पहले रहेगा तब ना मरने के बाद होगा
पहले रहे तो मतलब she had no right to property.
ये तो कहाँ किए अपने प्रॉपर्टी को तो नहीं दिए वो हस्बैंड का प्रॉपर्टी का डिस्ट्रीब्यूट
जब मेरे हस्बैंड मर गया तो हस्बैंड का प्रॉपर्टी क्या डिस्ट्रीब्यूट करें?
जो लिखा हुआ है हस्बैंड का प्रॉपर्टी
That was, you
वो अपने
see,
से एक लाइन यदि लिखा रहता है कि हम अपना शेयर को डिस्ट्रीब्यूट कर रहे हैं तो
इसीलिए तो ये तो आपको जब आप मेजर हो गए तो आपको जो भी चैलेंज करना था
नहीं है ना इसमें सेक्शन 8 और सेक्शन 15 दोनों में इसका कोई राइट ही नहीं बनता है वॉइड सेल डीड जो जुरिडिक्शन ही नहीं है दूसरा का जमीन को बेच देगा तो वॉइड होगा
बेचा
एज
नहीं
पर Hindu succession and manner this cell deed is void therefore it not required to challenge it within 3 years manner it is article
सेल डीड का
65
तो हो
will
गया काम खत्म सेल डीड का तो कोई मतलब नहीं
आर्टिकल 65 will apply इसमें सेक्शन 15 को देख लीजिए क्लियर कर दिया कि उनका माने हस्बैंड से मिला हुआ संपत्ति कैसे डिस्ट्रीब्यूट
हस्बैंड से मिला हुआ संपत्ति उनके मरने के बाद कैसे
नहीं
डिसाइड
किए ना जिंदा रहते कुछ नहीं किए
जिंदा रहते एलोकेट कर दिए
नहीं किए
बाय वर्च्यू ऑफ
तो
पार्टीशन
अपना इनको भी करना चाहिए था ना वो लिखते कि मेरा शेयर में 3 भाग होगा
अपना
अपना शेयर में 3 भाग होगा ना अभी
क्यों जरूरी है 3 भागों का
डोनेट नहीं किए हैं गिफ्ट नहीं किए हैं यदि पार्टीशन करेंगे तो 3 भाग होगा क्योंकि प्लेंटी को भी मिलेगा उनका शेयर तुम नहीं किए ना वो खाली किए हस्बैंड का प्रॉपर्टी को डिस्ट्रीब्यूट कर उसमें गिफ्ट नहीं है गिफ्ट होता तो तुम कर सकते तुम गिफ्ट नहीं किए ट्रांसफर ही है नहीं इसमें राइट होता ही नहीं है पार्टीशन
दैट्स ऑल
नहीं
the learned counsel for the appellant has submitted that the partition deed involved in the present case is Exhibit H, dated 29/1/1946, in which the plaintiff, his 2 uterine brothers, and his mother are the signatories. He submits that, admittedly, on the date of partition deed, the plaintiff was a minor and he attained majority in 1950. It is not in dispute that the parties are governed by Mitakshara law and the father of the plaintiff expired in 1942 and that the property was recorded in the name of the father. The learned counsel submits that the mother had no right to the property to allocate the same to the uterine brothers of the plaintiff who are otherwise not entitled to succeed to the property of the father. He has submitted that, in effect, the property has been transferred by the property of the plaintiff has been transferred to his uterine brother through partition deed, and such modus of transfer is void ab initio. And therefore, there was no need for the plaintiff to challenge the deed of partition. In such circumstances, the limitation prescribed under section 60, under article 60
Yes.
of the Limitation Act has no applicability. The Learned Counsel has submitted that after the death of the mother, the plaintiff was the sole successor of the property. And the entire property of his father would have devolved upon him, and his uterine brothers had no right to the property. He submits that in such circumstances, the transfer of property made by his uterine brothers while registered sale deed of the year 1973 and 1976 were void ab initio. And consequently it was not binding upon the plaintiff. He submits that the learned trial court has held that the challenge to the sale deed and the relief rate, the challenge to the sale deed and the connected relief was governed by Article 65 of the Limitation Act, as the plaintiff was seeking recovery of possession.
On condition of possession and
Confirmation of the recovery.
Confirmation/recovery of possession with respect to the property which was transferred, with respect to the property which was subject matter of sale deed of the year 1973 and 1976. The Learned Counsel submits that this finding of the Learned Court has been reversed by the Learned First Appellate Court, who has held that the challenge to the relief sought for, that the declaration sought for with respect to the two sale deeds would be governed by Article 58 of the Limitation Act, and has held that the relief in connection with the two sale deeds is barred by limitation. He has submitted that though no substantial question of law has been framed on the point of limitation, but still the court can decide it. The Learned Counsel has, on the point of limitation, the Learned Counsel has referred to the judgment passed by the Honorable Supreme Court reported in 2025 SCC Online 1961, Shanti Devi versus Jagan Devi, and has referred to paragraph
5, 30, 29, 30, 38 and 39.
paragraph 5,
Paragraph 29, 30, 38 and
29,
30,
30
38 and 39.
and
39.
आपका सबमिशन सही से लिखा दिए? The Learned Counsel for the respondents has opposed the prayer and has submitted that the husband having expired in the year 1942, the property would certainly devolve upon his widow and son, as by that time the Hindu Women's Right to Property Act 1937 had already come into force, and they had equal share on the property. In the partition deed, the Learned Counsel has submitted that under such circumstances, at best, the plaintiff had half share with respect to the property of his father, and the half share was with the mother. He submits that in the partition, the mother allocated her, the mother in the partition, half share was allocated to the plaintiff and half share was allocated to his two uterine brothers. The Learned Counsel submits that if there can be no doubt that the uterine brothers of the plaintiff formed a part of the joint family property of the joint family consisting of widow and his three sons and her three sons. One through the husband and two others through her previous husband. The Learned Counsel submits that if the plaintiff had any grievance in connection with the allocation of share, and particularly the allocation of share to the extent of 50% to his uterine brothers, he ought to have challenged the same within 3 years of attaining majority. The Learned Counsel has further submitted that the registered deed of partition dated 29/1/1946 was also duly acted upon by the parties, inasmuch as the plaintiff had asked the plaintiff and the defendant number and his uterine brothers had jointly sold property which was also subject matter of the partition, and therefore the plaintiff had acknowledged the right of his uterine brothers in connection with the property. He has further submitted that the sale deeds of the year 1973 and 76 were executed by referring to the deed of partition. The Learned Counsel has submitted that since no substantial question of law has been framed in connection with applicability of Article 59 of the Limitation Act with respect to the two sale deeds as decided by the Learned First Appellate Court, there is no scope for this court to enter into this dispute, as the second appeal has to be decided strictly on the substantial question of law framed by the court. He has also submitted that otherwise also the Learned First Appellate Court has rightly held that the challenge that the prayer seeking declaration that the two sale deeds of 1973 and 76 were not binding upon the plaintiff was barred by limitation by referring to Article 58 of the Limitation Act. The Learned Counsel has also submitted that the suit property involved in this case is only relating to the property covered by the two sale deeds, that is 1973 and 1976, and consequently and further the partition deed dated 29/1/1946 was not specifically under challenge in the suit, as no relief was prayed for in connection with the partition deed. He submits that the present suit will have a bearing only with respect to the suit property, that is the property covered under the two sale deeds of 1973 and 1976, and he is representing the purchasers of the property covered by the two sale deeds.
No, I am representing the persons whose sale deed is not under challenge. I said I am representing what defendant number 3, 4 and 5. So I am a person, my sale deed is not under challenge itself.
He submits that he is representing the persons whose sale deeds are not under challenge, and he had purchased the property by virtue of deed of the year 1966.
No, I am a subsequent purchaser, but I have been included as a party. There is a specific written statement to that effect that there is no relief against me.
Subsequent purchaser arising out of the same deed.
Arising out of the same partition deed. The Lordship is asking.
No, this 73, 76.
No, I am not connected to 73, 76.
Not at all.
Not at all.
You are connected with 1966.
1978, there is a subsequent deed by them. 78 in which my parties are purchased.
78 से आप किससे खरीदे?
But हम लोग खरीदे हैं डिफेंड नंबर 1 और 2 से.
Okay.
लेकिन वो सेल डीड चैलेंज ही नहीं.
Okay. The Learned Counsel submits that the defend number 4 and 5
Yes.
are the persons who had purchased property from defend number 1 and 2 by other sale
By
deeds,
other sale deeds.
which is not under
It is not under
challenge
challenge.
in the present case, but at the same time those properties are also involved in the partition
Yes.
deed dated 29/1/1946. That's all. Arguments concluded.
But one judgment which I referred to 2019,
Exactly.
वो Article 61.
The Learned Counsel has relied upon the judgment reported in
1920 ACC.
2019 ब्रैकेट में रहेगा 20 SCC 633. Any particular para?
Yes. But paragraph would be not 28, 29 would suffice.
Paragraph number 28 and 29.
Yes. This is after attaining majority vote within 3 years.
To submit that, the plaintiff ought to have, plaintiff if aggrieved by the partition deed dated 29/1/1946 ought to have challenged the same within a period of 3 years from the date of attaining majority, which admittedly he attained in the year 1990.
इसमें एक ही चीज लास्ट खाली एक लाइन बोलना है कि इसमें एडवर्स पोजीशन में अलाउ हुआ था. एडवर्स पोजीशन और टाइटल एक साथ नहीं रह सकता है. जब टाइटल को छोड़ देते हैं
एडवर्स पोजीशन में किसका अलाउ हुआ?
उनका मतलब सिविल अपील जो अलाउ हुआ उनका एडवर्स पोजीशन.
किसका एडवर्स पोजीशन?
डिफेंडेंट नंबर 1, 2, 3 सिविल एप्लेट का
लिमिटेशन में ही सूट बोल दिया कि
नहीं, उसको तो पार्ट ऑफ द सूट भी है, तो उसमें है कि टाइटल और एडवर्स पोजीशन एक साथ कोई क्लेम नहीं कर सकता। तो एडवर्स पोजीशन से होगा मतलब दोनों कोर्ट का कॉन्करेंट फाइंडिंग है,
तो
उनका टाइटल नहीं।
फाउंडेशनल प्ली ही नहीं है तो एडवर्स पोजीशन का फाइंडिंग तो सेट असाइड ही होगा ना।
नहीं, वो तो होगा, लेकिन हम बोल रहे हैं जब एक बार क्लेम कर चुके हैं एडवर्स पोजीशन मतलब टाइटल छोड़ देने के बाद एडवर्स पोजीशन का क्लेम होता है। तो जब एडवर्स पोजीशन का प्ली ले चुके हैं तो मतलब टाइटल उनका नहीं है, वो मान चुके हैं।
The learned counsel for the appellant in response has submitted that the appellate court has recorded a finding in favor of the defendant number 1 to 3 with respect to the suit property on the point of adverse possession, and since no foundational plea was taken in connection with the adverse possession, therefore the finding recorded by the learned first appellate court on the point of adverse possession is certainly fit to be set aside। यही बोल रहे हैं आप?
नहीं, हम बोल रहे हैं कि
ये बोल रहे हैं कि नहीं बोल रहे हैं?
नहीं बोल रहे हैं माइलर, हम
तो
इंटरप्रेट करने
एडवर्स पोजीशन का फाइंडिंग रहना चाहिए।
नहीं, हम बोल रहे हैं कि जब वो प्ली लेते हैं कोई तो पहले छोड़ देते हैं टाइटल का
That's
प्ली
right.
को छोड़ देते हैं आफ्टर रिनाउंसिंग द क्लेम।
No, that you have already had, but I want to know from you।
यस,
आपके फेवर में बोलते तो भी आपको समझ नहीं आता है, तो इसका तो हम समझा नहीं सकते आपको।
नहीं, हम दूसरी चीज
हम आपसे ये चीज पूछ रहे हैं कि अगर एडवर्स पोजीशन का फाइंडिंग है और फाउंडेशनल प्लीडिंग नहीं है डिफेंडेंट का, तो वो फाइंडिंग रहना चाहिए कि
नहीं रहना चाहिए, लेकिन जब एक बार क्लेम कर देते हैं तो अपना टाइटल को
वो
छोड़
तो हम लोग ऑलरेडी लिखा चुके हैं।
नहीं, माइलर पार्टीशन डीड के ऊपर उनका टाइटल डिक्लेयर कर रहे हैं, उसी लिए हम बोल रहे हैं कि वो एक बार जब एडवर्स पोजीशन का प्ली ले लेते हैं तो अपना टाइटल छोड़ देते हैं।
The learned counsel has also submitted that they दोनों चीज नहीं बोल सकते ना कि प्ली भी लिए हैं और नहीं भी लिए हैं।
नहीं, हम बोल रहे हैं कि दोनों एक साथ ही प्ली नहीं ले सकते हैं, मतलब टाइटल और एडवर्स
The
पोजीशन का
learned counsel has submitted that the defendant number 1 and 2 could not have simultaneously taken plea of title and adverse possession. Title based on the partition deed dated 29/1/1946. Right? However, it is not in dispute that the foundational plea in connection with claiming adverse possession was not pleaded by the defendant in the written state।
फाइंडिंग है लैंडेड कोर्ट बिलो का कि उनका कोई टाइटल नहीं, ये रिवर्स नहीं हुआ। फाइंडिंग माइलर का सबसे फाइंडिंग है लैंडेड कोर्ट बिलो का कि उनका टाइटल नहीं है।
किनका?
डिपेंडेंट 1 नंबर 2, 1, 2, 3 कोई टाइटल नहीं है, फाइंडिंग है लैंडेड कोर्ट बिलो का। वो एपेलेट कोर्ट में भी वो फाइंडिंग रिवर्स नहीं हुआ।
The learned counsel has also submitted that the trial court has given a finding that defendant number 1 to 3
यस,
3 कौन है? 3 नंबर कौन है?
3 है
तीन
जो
नंबर
परचेस
किए।
परचेस
1 2 बेचे।
अच्छा। Defendant number 1 to 3 have no title over the suit property, and this finding has not been
रिवर्स।
reversed by the learned first appellate court, and no such substantial question of law has been named। बस इतना ही बहुत। अब तो एक ही है कि 84 का कहानी हम खत्म कर दें, बस यही बहुत है। पार्टी को तैयारी करने में मेरा हालत खराब, पूरा रिकॉर्ड गुम हो गया। एंड देयर इज अ डायरेक्शन ऑफ द सुप्रीम
Yes.
कोर्ट।
To conclude within 3 months.
हाँ, तो आज तो
29/7/2025 if I'm not correct.
कौन दिया है डिक्टेशन? आप दिए हैं, इसका काम है आप ही के पास।
from tail is forgery under order 41 rule 11 item 19 second appeal 233 of 2023.
Yes, appellant. Who are you? Plaintiff or the defendant?
Suit your worship was for suit for partition. The suit was decreed. It was completely decreed with respect to 2.25 acres of land. And for the rest of it, it was
Partly decreed for?
partly decreed for 2.25 acres of land.
Suit property was how much?
Suit property, your worship, was apart from that, there were other lands also.
Okay.
Other lands also. But one of the land, not agreed, only that the treatment used that much of document. One of the, we don't find one of the written statement, but one of thereafter, one of the defendants did not reduce any of them, and one of the suit was actually.
Are you serious?
Next part.
Are you serious about the case?
Yes, I am now.
Not serious. Written statement file करने के बाद you were not serious.
That what is the fact that I have to press.
तो क्या कर सकते हैं?
बता दें। इसमें एक्चुअल में प्लेंटिफ का केस ये है कि ठाकुर साहब की जमीन है और ठाकुर साहब की एक्चुअल में दो है। One was Moti Devi and another was Shivani Devi. They claim that they are the out of the wedlock, they have been born and these
two wives.
two wives.
क्या बता देवरानी?
One is Moti Devi.
मोती.
Moti Devi.
M.O.
Yeah, Moti Devi. Through whom the defendants are the
Defendants.
yes. And so far as Shivani ownership is concerned.
Shivrani.
But the plaintiffs claim that after death of Moti in the year 1955, there was a second marriage with Shivani. Our stand in the written statement
Just a moment. Just a moment. Plaintiffs. They were second married with Shivrani.
Shivani in the year 1955. That is their pleading.
Shivrani 1955.
Right.
So?
Then they claim, the plaintiffs claim that out of that wedlock, the plaintiff and they have been born and they have a right in the property of that is what they are pleading. So far as the defendant is concerned, they specifically pleaded that she was not the wife of Thakur Sahib. Rather, he was the wife of Paleswar Ram.
Shivrani Devi was not the
Not the
wife
wife of Thakur Sahib. He was wife of Paleswar Ram. And they have been, the plaintiffs have been born out of that with Paleswar. And to substantiate that ownership, we have stated in para 12 of the written
Excellent. And Shivrani Devi and
Paleswar. Now, their stand ownership that they are the wedlock out of the that wedlock they have won. Our specific standing that she was the wife of Paleswar, not the Paleswar. And to substantiate that ownership in the written statement of para 12, we have stated that in the year 1957, Malad she had purchased a property. In that Malad Sending Your Lordship, the name of Paleswar Ram Your Lordship is there. Malad, that's because the defendants Malad did not appear before the trial court, and the appeal was referred by them. So Malad, to substantiate that Your Lordship, we have also filed Malad that Sending on record by way of Article 226. From their perusal of Your Lordship, from the Senate, my lord will get that she is wife of Paleswar now, and the claim, my lord, that she was married.
When did Thakur Saab die?
Thakur, as per them, Your Lordship.
As per you, बताइए ना.
Yes. Thakur Saab died in the year 1986. That is their pleading.
That is their plea.
That is
And what is your case?
my case, Your Lordship, is that. My specific case, Your Lordship, that we are the sole legal heirs, and there is no case of second marriage.
When did Thakur Saab die? Was it your case that he never existed?
No. Thakur Saab, we are the descendants of the
Thakur Saab. When did he die?
That date of death, Your Lordship, perhaps it is not here, but I will verify.
Why didn't you adduce evidence at the stage of trial?
No, that is a very pertinent question also. My lord, really asked this question. But whatsoever they were reasoning, they did not appear. And they did appear, except defendant number 4. And others had filed it in this case. But no, that is what.
Why didn't you take this plea at the first appellate stage?
But first appellate stage, they have, that is in the written statement.
Why didn't you take steps for adducing additional evidence at this first appellate stage? And the second appellate stage, you want that, so you will rise from the slumber anytime you want. Does the law permit it?
But so far as the law is concerned.
And this document will be adduced into evidence without oral evidence.
No, I'm saying what I'm saying.
No, ये सब नहीं चलेगा, Mr. Sharma.
Sharma.
Registered होने से क्या हुआ? रखे रहिए अपने घर में. No, we are not going to permit this. We will not permit
Had
this.
it not been in the written statement, I could have.
We will not permit this. Even if it was there in the written statement, you are supposed to appear and lead your evidence and exhibit it.
I agree.
Then
But that from their perusal of the deed itself will repeat that she is the wife of.
लिटिगेंट की गलती से, ठीक है, पहला लिटिगेंट की गलती से, दूसरा एडवोकेट की गलती से. एवरीबडी हैज टू सफर. डॉक्टर की गलती से पेशेंट मर जाते हैं, लिटिगेंट की गलती से, एडवोकेट की गलती से लिटिगेंट मर जाते हैं, और लिटिगेंट की गलती से तो मर ही जाते हैं. इसका तो कुछ कर ही नहीं सकते हैं. और कहाँ है आपका एडिशनल एविडेंस? पहले तो उसी को रिजेक्ट करके आपका अपील ही रिजेक्ट कर देते. कहाँ है आपका आइडिया? हमको क्यों ही देखना है? जब मौका था तब दिखाई नहीं, अब देख के क्या करेंगे? हमको देखना ही नहीं, उसको रिजेक्ट करेंगे सबसे पहले.
हमने अपेयर नहीं किया, एक सेकंड, हमने अपेयर नहीं किया, इसका मतलब भी थोड़ी है कि उनको सूट अलाउ करना है.
ठीक, एविडेंस के बेसिस पे अलाउ किए ना, बिना एविडेंस के तो नहीं
एविडेंस
अलाउ.
के बेसिस पे भी बहुत सा ऐसा एविडेंस, जैसे एक एविडेंस ये आया नहीं कि उनका अपना एविडेंस.
कहाँ है आपका? आइए नहीं है. आइए का नंबर बताइए. आइए का नंबर बताइए. एक आइए है 9742 और 25, राइट. दिस इज रूल 26 का.
Slide number 317 of 2026.
317 और 26 कहाँ है? फाइल किए हैं सर? कब फाइल किए हैं? साथ में क्यों नहीं रखते हैं भाई? अच्छा और बताइए क्या?
हाँ, इसमें दूसरा पॉइंट ऑफ लॉ में ये है कि सिर्फ ये वोटर आई कार्ड और राशन कार्ड के आधार पर और स्कूल रजिस्टर का एक ट्रांसफर सर्टिफिकेट वगैरह लगाएं जो कि इन अकॉर्डेंस विद लॉ प्रूफ भी नहीं होता है, उसके आधार पर ही इनको राइट दे सकते। आधार कार्ड और राशन कार्ड और वोटर आई कार्ड से तो पैरेंटेज कभी डिटरमाइन हो ही नहीं सकता। ये पॉइंट हमने फ्रेम किया। Whether the appellate court by impute judgment and decree committed serious error of law as ought not to have partly decreed in absence of conclusive evidence of plaintiff that they are descendants of Thakur. Whether in absence of conclusive evidence with regard to parentage of plaintiff can Government Trial Court partly decree the suit with respect to property measuring an area of 2.25 acres which is in the name of Thakur. Whether the judgment and decree passed by the appellate court is appreciated as it failed to consider the evidence of PW1 and PW2 vis-a-vis written statement for 10 and 11 of the written statement which show that Thakur saw had 3 daughters who were necessary party in the suit and were not maintainable for non-joinder of necessity. Whether the appellate court committed serious error of law in partly decreeing the suit taking adverse inference against the defendant for non-appearance after filing their written statement without appreciating the basic principle of law. Order of proof is now plaintiff from the absence of such ये पिटिशन को अगर रिकॉर्ड से नहीं भी मानते तो भी बर्डन इज ऑन प्लेंटिफ एंड नॉट इन द एविडेंस इट हैज कम।
आपके ऊपर बर्डन नहीं था प्रूव करने के लिए,
हम क्या
तो उनके हस्बैंड का नाम आप दे रहे हैं।
ऊपर तो है बर्डन, लेकिन मान लीजिए हम अगर नहीं भी प्रूव कर पाए तो भी, लेकिन अगर इनको अगर डिग्री चाहिए सूट में प्रॉपर्टी में अगर डिग्री चाहिए तो कम से कम अपना केस तो प्रूव करें।
आप They had a cakewalk completely because you did not adduce any evidence. You did not even adduce oral evidence in support of your written statement. Written statement का क्या relevance है? What is the relevance of written statement?
My lord, so far as the plaintiff fellowship is concerned, even in absence fellowship of defendant, the trial court can only decree a case, my lord, and when it is, my lord, proof beyond, my lord, at least probabilities it should be there that there is a probability of that. Otherwise, how? And then apart from that, there were several other properties apart from the only they could the suit was partly decreed. It had to be dismissed for so far as the other parts. But how it can be, my lord, that suit can be partly decreed if he is the son of a Thakur sovereign, he has property, he has share in all the property. और इसमें खुद भी इनका एविडेंस में भी आया है कि देयर वर डॉटर्स ऑफ ठाकुर साहब, उसको भी तो पार्टी नहीं बनाया, मैं ज्वाइंडर ऑफ नेसेसरी पार्टी के लिए भी तो हम उसमें बाढ़ है। अगर आगे कोई हुजूर नहीं भी अगर देखा जाएगा उसके बावजूद भी हजूर इसमें ये पॉइंट बनता है। शिवरानी देवी का मैरिज भी प्रूव करते वो भी नहीं किए, कोर्ट ने उस पर कोई फाइंडिंग भी नहीं दिया कि हाँ शी इज वैलिड वेटेड बाय आदित्य, इसमें है ऐसा नहीं है। PW1 and 2 का भी गवाही में भी आया है कि हाँ उनको लड़कियां हैं, तो उनको तो पार्टी नहीं बनाए, नॉन वाइडर के लिए तो सूट पार्ट तो डेफिनेटली होता। हमारा रिटर्न स्टेटमेंट में भी बात लिखा हुआ है। सेक्शन 50 ऑफ एविडेंस एक्ट में रिलेशनशिप प्रूव करना होगा। और जब हम सेडिट के बारे में जिक्र किया था रिटर्न स्टेटमेंट, तो सेडिट हम ऑर्डर 41/27 ला रहे हैं और उसको उसका बेयर क्लोजर से हम देख सकते हैं कि परस्पर नाम का इसमें इनका जॉर्जे कलिस्टर नाम लिखा हुआ है। अगर 55 में अगर ठाकुर साहब के साथ शादी हो गई तो 57 में सेडिट ले रहे हैं, उसमें जॉर्जे ठाकुर साहब होना चाहिए। ऐसे भी कानून यही है कि अगर पास करना है प्लेंटिफ को प्रूफ अपना केस करना है, और अगर डिफेंडेंट नहीं भी अपीयर करता तभी इनको पॉइंट जो भी डिटर्मिनेशन बना करके करना या डिसमिस करना simply because the defendant has not appeared, the suit cannot be decreed in absence for his absence. That's your argument. और हमारा ये वाला जो ये पिटीशन जो हम फाइल किए हैं उसका रेफरेंस हमारे मेमो ऑफ अपील में ही है। हमारा ये चीज़ लिखा हुआ है कि हम ये पिटीशन फाइल करेंगे, इसको उससे रीड बनाएंगे। रिटर्न स्टेटमेंट ऑलरेडी था सर, राम उसमें लिखा। और अगर 57 का सेल अगर रिकॉर्ड पे है जिसमें उनका हस्बैंड का नाम कॉलेश्वर राम लिखा और रिटर्न स्टेटमेंट में भी बात लिखा हुआ है, तो इसको तो हम लोग कंसीडर किया जाए। अगर कॉन्डिशनल फैक्ट नहीं होता तो नहीं। सेकंड प्रॉब्लम में देखा जाएगा श्रीमती शिवरानी राम वो जॉर्जे कॉलेश्वर, इनका अपना प्लीडिंग है कि इनका 55 में डेथ हो गया, 55 में ही शादी की है। प्लॉट भी वही 2698 12 डिसमिल का जमीन ये होगा अपना रिटर्न स्टेटमेंट को हमने लिखा।
Essay number 233 of 2023 with IA number 317 of 2026. This appeal has been filed against the judgment dated. क्या चीज?
ये हमने लिखा है बड़े डिस्ट्रिक्ट जमीन के बारे में हम इसको लिखे हैं।
This appeal has been filed against the judgment dated 5/7/2023 within bracket decree dated 18/7/2023 bracket close passed by the District Judge 1 Palamu at Daltonganj in Partition Appeal number 26 of 2010, affirming the judgment and decree dated 23/4/2010 within bracket decree signed on 12/5 2010, passed by learned Sub-Judge Roman to Palamu at Daltonburg in Partition suit number 117 of 2004. The learned counsel for the appellant has submitted that the appellants by the defendants in the suit, though they filed written statement, but thereafter did not accept defend number 4, but they did not lead any evidence before the court. Consequently, the court proceeded under Order 8 Rule 10. The court proceeded under Order 8 Rule 10 of the CPC, and the suit was decreed. He submits that the specific case of the plaintiff was that the entire suit property was owned by Thakur Sao, who had a wife, namely Moti Devi, and the defendants are the descendants through Moti Devi. Their further case was, upon death of Moti Devi, Thakur Sao married Shivrani Devi, and the plaintiffs
In the year 55.
in the year 1955, and the plaintiff claimed that they are the descendants of Thakur Sao through Shivrani Devi. The learned counsel has submitted that the suit was partly decreed only in connection with part of the suit property to the extent of 2.25 acres, as the plaintiff could produce documents in connection with the ownership of the property in the name of Thakur Sao only to that extent. He submits that though the defendants did not adduce any evidence, but as per the written statement, Shivrani Devi was not the wife of Thakur Sao, and consequently the plaintiffs were not born out of wedlock between Shivrani Devi and Thakur Sao. It was their further case that Shivrani Devi was the wife of one Koleshwar Ram. He has submitted that in the written statement at paragraph 12, a specific statement was made that to prove that Shivrani Devi was the wife of Koleshwar Ram, that she had purchased a property, purchased a property in which,
In the year 1957.
in the year 1957, in which name of her husband was shown as Koleshwar Ram. He submits that as per the case of the plaintiff, Thakur Sao had died in the year 1986. Therefore, it was for the plaintiff to prove that
As per them, Shivrani Devi she married with Thakur Sao in the year 1955, but the salary which is being purchased by her in the year 1957 is showing the name of the Koleshwar Ram, which is your Ashik is not relevant.
at that time when the sale deed was being executed, purchaser never used to sign also. Never used to sign. It was only the seller who used to sign the sale deed. पता है ना आपको ये बात?
Maybe.
मे भी मतलब, और दूसरा बात क्या है कि आपका ये एडिशनल एविडेंस तो बिल्कुल नहीं चाहिए।
नहीं ऐसे आप कम से कम हमारा अगर
नहीं
रिटर्न
नहीं नहीं, आपको सुन लिए ना मिस्टर शर्मा, आपको 15 मिनट सुन लिए, अब ऑर्डर सुनो। The learned counsel submits that the case of the plaintiff was that Shivrani Devi had married Thakur Saur in the year 1955.
टोटल लिस्ट के आधार पर उन्होंने इसमें डिग्री कर
He has also
टोटल
submitted
लिस्ट में
that
हमारा बार-बार
yes, he has also submitted that one of the documents which has been considered by the learned court to decree the suit is the voter list, which by itself cannot be said to be a document to show that Shivrani Devi was the wife of Thakur Saur.
वोटर लिस्ट राशन कार्ड एंड स्कूल ट्रांसफर ये थ्री
Voter list, ration card and school transfer certificate. He has submitted that one IA has been filed seeking to adduce additional evidence before the first appellate court,
सेकंड
before the second appellate court, by seeking to bring on record the copy of the sale deed number 5775 dated 16/2/1957 executed by Ramchandar Ram in favor of Srimati Shivrani Devi, wife of Koleshwar Ram. A photocopy of the said document has been annexed along with the interlocutory application.
शी हैव टेकन दिस ग्राउंड इन द मेमो ऑफ appeal also ग्राउंड नंबर 11
He submits that at ground number 11, it has been stated that a separate petition under Order 41, Rule 27 is to be filed for additional evidence. During the course of hearing and upon perusal of the interlocutory application, the counsel for the appellant is not in a position to say as to why the defendants failed to participate in the trial, and further, in spite of filing appeal before the first appellate court, why no steps were taken for adducing additional evidence.
ये तो हमको लिखे हैं 4 में तो लिखे हैं कि हमको
In paragraph 4,
हमको जब इसमें
it has been stated,
सच और किए
in paragraph 4 of the interlocutory application, it is stated that Brahmadev Agarwal, who was appellant number 2 in Partition, appeal number 26 of 2020, he died on 25/6/2023, and after his death, his legal heirs searched his box and came across the sale deed number 5775 dated 16/2/1975. And thereafter they showed the document to the advocate, and ultimately the interlocutory application has been filed. This court is of the view that the written statement itself had mentioned about the sale deed number 5775 dated 6/16/1957.
डेट नहीं है हम उसका वर्णन से जो इसलिए हम के समझ में ऐसा है डेट का नंबर
कुछ भी नहीं है कौन से साल में परचेज की. Nothing has been mentioned in which year it was purchased. लिखे, जमीन तो लिखे, कौन सा साल में परचेज किए?
वो चीज आया है कि परचेज किए हैं कितना आया? 12-13 दोनों पैराग्राफ अलग है। सेल लीड का इम्पोर्टेंस सिर्फ इतना ही है कि टू सपोर्ट आवर कंटेंशन दैट
He has produced a copy of the written statement wherein, though it has been mentioned that Shivrani Kaharin लिखे, श्रीमती शिवरानी कहारिन had purchased certain property. But the details of such property has not been disclosed in the written statement also. This court is of the considered view that the additional evidence sought to be adduced through IA number 317 of 2026 and the explanation for not taking appropriate steps at the trial court and even at the first appellate court is completely missing from the interlocutory application. Further, this court is of the view that this court does not require the additional evidence to decide this case. Accordingly, IA number such and such is hereby rejected. So far as the main appeal is concerned, this court finds that the suit was filed seeking a preliminary decree for partition having 2/7 share in favor of the plaintiff with respect to the suit properties. The learned trial court the learned trial court recorded that the defendant number 123 and 529 had appeared and filed written statement on 9/3/2005, but they left badly from 25/1/2006. And in the meantime, the case was running for appearance of defendant number 4, who did not appear in spite of repeated opportunities. The plaintiffs, the repeated opportunities were granted to the defendants, but they did not turn up, and the trial was undertaken under the provision of Order 8 Rule 10 of CPC. Consequently, the defendant number 123 and 529 had not come before the court to support the pleadings of their written statement. The trial court also recorded that from the bare reading of the written statement, it appeared that they denied the relation with the plaintiffs, and they also denied that the plaintiffs were the members of the joint family. The trial court frame the point for decision as follows: whether there is unity of title and unity of possession to the suit land between the parties, whether the plaintiffs are entitled to get 2/7 share in the suit property. The trial court considered the oral and documentary evidences. The court ultimately decreed the suit by holding that only to the extent of 2.25 acres of land and held that there was unity of title and unity of possession amongst the parties. The court also recorded that the plaintiffs pleaded and led evidence to prove that Thakur Saab had married his two wives, and first wife was Moti Devi. She died in 52-53, and from the wedlock of Thakur Saab, Moti Devi and 5 sons were born, and they are the dependents. And from the second wife, Shivrani Devi, the plaintiff was born. The court also recorded the stand taken by the defendant in the written statement about the purchase by Shivrani Devi, but observed that the defendants had not come forward to adduce any evidence. And in absence of the evidence of the defendants, there was no option to disbelieve the fact and evidences which were placed on record by the plaintiffs. The court recorded the documentary evidences placed on record, including the election identity card of the plaintiff to show that he was the son of Thakur Saab, transfer certificate which was issued by the headmaster of Ganesh Lal Agarwal Vidyalaya, Daltonganj, dated 8/7/1976, in which Thakur Saab was shown as the father of the plaintiff number 1, which was marked Exhibit 2, and also ration card to show that he was the son of Thakur Saab. And there was no document on record before the court to disbelieve these documents, to show the relationship between the plaintiff and Thakur Saab. The court ultimately held that the plaintiff number 1 had 1/7 share, plaintiff number 2 1/7 share. and decreed the suit with respect to 2.25 acres, for which the documents were produced to show that the property belonged to Thakur. The learned first appellate court the defendants were the appellants before the learned first appellate court, and the learned first appellate court also gave concurring findings. After formulating the point for determination as to whether the judgment and decree of the trial court suffers from any illegality or irregularity or was bad due to a defect in law and was to be satisfied.
It is partly corrected. उनका defendant number 4 के against में भी suggestion required है. So court ने correct.
Sorry, defendant number 4 को?
4 के against में भी trial court ने कहा था कि consistent लिखना है. To that extent it has been voted by the appellate.
Okay, the learned,
That mechanism.
the learned court has corrected the error committed by the learned trial court so far as defendant number 4 is concerned. Yes, I am. By paragraph 20 and 22 as follows. ठीक है?
उनके against का address maintain किया. Defendant number 4
Ex parte.
Ex parte.
बोलो. And the court held that the proceeding against the defendant number 4 was ex parte. This court finds that the learned courts have passed a judgment based on the materials on record which does not suffer from any illegality. The relationship was duly proved on the basis of oral and documentary evidences placed on record. This court finds no merit in this appeal, which is hereby dismissed. ये आपको दे देंगे, ये रिटन स्टेटमेंट आपको वापस हो जाएगा, अभी रहने देते हैं.
Item 20, second point 207 of 2025.
ये जरा देखिए.
In this case, the student number 1, 2 and 3 have diagnosed.
Well,
Looks like I don't know.
essay number 207 of 24. The learned counsel for the appellant has submitted that he has been informed that the respondent number 1, 2 and 3 have expired. कोई तो अपडेट, कोई तारीख, कोई साल, कोई दिन, कोई महीना. सब्स्टिट्यूशन में तो लिखिएगा, लेकिन बताइए कब बने. ऐसा कैसे हो सकता है? आपको कोई फोन करेगा तो आप ये उससे ये नहीं पूछेगा कब बने. अरे कोई साल, कोई सेंचुरी बताते हैं ना कम से कम. सेंचुरी भी नहीं बताए. 1991 का टाइटल सूट है ना, इसीलिए सेंचुरी भी पूछ रहे हैं हम आपसे. कौन सा सेंचुरी में मरे? कौन है रिस्पॉन्ड नंबर? या आपके कोई रिलेटिव है? कौन है?
नहीं, रिलेटिव नहीं. हाँ, रिलेटिव नहीं है. रिलेटिव नहीं. पार्टीशन सूट हुआ है.
पार्टीशन सूट है ना.
सॉरी, टाइटल सूट was filed for declaration that the plaintiffs are the legal heirs of the recorded tenants.
सबका रेजिडेंशियल एड्रेस वगैरह सब सेम है.
हाँ.
बहुत मुश्किल होगा आपको बताने में कि आपको पता नहीं था.
नहीं, हमको बताया नहीं, इसीलिए हम नहीं.
आपको नहीं, आपके लिटिगेंट को नहीं.
हाँ.
ना?
उसमें सब्स्टिट्यूशन में देखा जाएगा. 2 weeks notice simply.
Post on 19th February. कौन कौन रेस्पोंडेंट बोले हैं? इसमें कोई एरर नहीं हो। रेस्पोंडेंट नंबर कौन कौन भरे हैं?
एक 1, 2 and 3
1, 2 and 3
जी।
ठीक है।
देखिए जो कल हम लोग एडमिट हुआ है उसमें कुछ एरर आ गया है। So I have put up this here from 18/2/2026 इनको भेज दिए इनको मास्टर साहब 18/2/2000 कल ही एडमिट हुआ है हम लोग।
किसका ऑर्डर? व्हाट टाइप की?
Item 21, the second appeal 216/2025.
This is a defendant second appeal against the judgment of affirmance. The plaintiff filed partition suit claim
कुछ नहीं है ना? है?
है हम बता दे रहे हैं। उसमें 3 सब्सिक्वेंट क्वेश्चन अपील है जो उसको हम पहले बता देते हैं वो जरूरी है उसके बाद हम फैक्ट सुनाते हैं। नहीं रहता तो हम तो पहले ही बोल देते हैं।
बताइए।
पार्टीशन सूट में हमारा टाइटल डिसाइड कर दिया और लेटेस्ट जजमेंट सुप्रीम कोर्ट का ये सूट को पार्टीशन टाइटल कैन नॉट बी डिसाइडेड हम जजमेंट दिखा रहे हैं।
अच्छा बताइए ना कौन सा सब्सटेंशियल क्वेश्चन ऑफ लॉ?
जो पेज 15 में देखा है
हां
Roman 3 whether a complicated question of title can be decided in a simple suit for partition and the findings to the first appellate court otherwise in this regard is wholly erroneous and saving against the mandate of law. Latest judgment जो बोल रहे हैं suit for partition title cannot be decided and second substantial question of law is 5 laws in page 16 whether findings of the learned first appellate court is vitiated due to misconstruing the exhibit A by 2 हमारा है that is compromise petition filed in title suit number 52 of 1964 acknowledging the position of the defendant over the suit land। इससे पहले भी पार्टीशन एक टाइटल सूट हुआ है तो कंप्रोमाइज हुआ है डिसमिस हुआ उसमें डिफेंडेंट पे उसको कोर्ट बोला है कि नहीं उसको कंसीडर नहीं किया है।
पार्टीशन सूट में कॉम्प्रोमाइज हो गया ना?
नहीं पार्टीशन सूट नहीं इससे पहले भी जो प्लेंटिफ है टाइटल सूट हमारे अगेंस्ट में फाइल किए थे उसमें कंप्रोमाइज हुआ तो सूट डिसमिस हो गया उनका सूट डिसमिस हो गया एग्जिबिट A by 2 and page 19 lordship
So it was not disposed of in terms of compromise.
it was disposed by terms of compromise acknowledging the position of the appellate's lordship and lordship page 19 lordship
ये acknowledging the possession of these defendants मतलब president
I am the intervener the plaintiff filed partition suit and included the plot number 489 490 and 920 lordship. Thereafter the intervener filed an application for pleading as a defendant lordship which was allowed lordship. Thereafter filed the written statement lordship. Now lordship may kindly see sorry page 19 lordship third substantive question of law admitting the claim by Roman 13 lordship whether in view that defendant number 4 namely Hakim Mahara in part 12 of the cross examination has been admitted that he was given land to the Ravi Chandra for construction of residential law as such it is well proved that the appellants have possession of the land since 5/3/1996 and judgment will be passed to the land court where wholly erroneous and saving against the mandate of law. Now lordship may kindly see case of the intervener lordship
आप इंटरवेनर बने
हम
थे
इंटरवेनर थे
पार्टीशन सूट में इंटरवेनर का क्या काम
है कहाँ
यू आर द फैमिली मेंबर
इसी पे अलाउ हुआ ना हमारा प्लॉट नंबर जो है पार्टीशन सूट का प्लॉट नंबर 489 490 and 920 इसको एक्वायर किए इन द ईयर 1937 बाय वर्च्यू ऑफ कुर्फानामा उसके बाद 64 में पार्टीशन टाइटल सूट भी फाइल किए जो प्लेंटिफ में भी हैं वो डिसमिस हुआ बाय टर्म्स ऑफ कंप्रोमाइज उसको कोर्ट लर्निंग कोर्ट में लोग कंसीडर नहीं किए दोनों कोर्ट और हम लाए लॉटरी मैकेनिज्म एग्जिबिट्स लो
अब जजमेंट दिखाइए
हां देखिए
द टाइटल कैन नॉट बी डिसाइडेड इन
यस पहले इशू में आ जाते हैं पेज 17 में लर्निंग ट्राई कोर्ट जजमेंट इशू whether the intervener defendant number 22 and 23 on their descendants have valid right title possession over the suit on the basis of Panama settlement dated so and so, so and so. Now, Lordship mechanistic findings. Page 34, Lordship. Roman 5.
ट्रायल कोर्ट का जजमेंट में पेज नंबरिंग नहीं
ऊपर में दिया हुआ पेज 34 है, पेज 34 रोमन 5
नहीं, इसमें कोई
हम दिखा देते हैं। एकदम ऊपर में ऐसा लग रहा है पेज नंबर नहीं 33 के बाद 34 है। The moreover, interpreter dependent file the exhibit E by 2, F by 2, and I by 2. On period exhibit E by 2, it transpires that the plaintiffs have mentioned the land of plot number 489 and 490 of Java Mandir number 39 has given Bolai system. Only no any code Panama has been mentioned. On period exhibit I by 2 has been filed with an interpreter dependent. This written statement will tell me on going through the written statement dated 28/1964. It is transferred no mention of the both the code Panama. Tahal has also mentioned that his possession of land since more than 20 years. On what basis the document has originally right has not been mentioned on period of the exhibit F by 2 is transferred. No any description of Kurpa has been made. On period of the exhibit G2 is transferred. The suit has not been decreed on terms of compulsion. The suit is dismissed. In terms of compulsion, no any decree has been filed before that. Any decree is required in the title suit number 52 or 64. Showing any possession of the intervener dependent on the basis thereof there is no right title or possession of the
बोल रहा है कि the suit was not decreed in terms of compromise.
So we can see that exhibit E by 2 not have given. He can say that I am not entitled to get any share lordship, but he is decided we can see the Honorable Supreme Court judgment lordship.
Because you see what happened, your intervention was allowed.
Hello.
You are not a member of the family.
I am not member of the
That's right.
family.
Since your intervention was allowed, so your right was also involved.
He can say that I am not entitled to get any share, but he has decided the
No, it is not.
mechanism.
If in a partition suit, a third party is intervening, who is not a member, who is admittedly not a member of the family, and the intervention is allowed,
So far as partition,
then what will the court do?
If the right title is involved or in partition suit, there is not necessary for all the parties may be the member or not member.
No.
It is not necessary.
No. In partition suit, all the parties are either the purchasers from the family members are the parties in partition suit at times, or the family members. But an alien is intervening in a partition suit, and intervention is allowed by claiming that he is the owner of the property.
But the admitted my claim, lordship. The defendant admitted my claim.
That is a separate thing. So when you say that the court had no jurisdiction to enter into the title, you invited jurisdiction on title, no?
But the suit.
But you are not getting it. In a partition suit, if a person intervenes, claiming that the entire property belongs to me and it is not the property of the parties,
Yes.
and that intervention is allowed, then the court has no option but to decide your title.
I don't decide. The Supreme Court says that.
But the very fact that you should not have intervened in the suit.
Because
But once the intervention is allowed,
because my plot has been included in say partition suit.
that's right. If a plot is included in the said partition suit, and if you intervene and claim title, then certainly the court will not proceed with the partition suit unless the title is decided.
But in a partition suit, title cannot be decided.
So what were you for?
Lordship, he can say that I am not entitled to get any share of that.
You did not claim any share. You claimed title. You did not claim any share. Your case was that the entire property belongs to
the title, but the learned court can say that I am not entitled to get the share in a partition suit, lordship.
No. The court will, if the court has to give a finding whether this particular property can be subject matter of partition suit or not, then the court has to see. If an intervention is allowed, then the court has to examine as to whether you have any right, title or interest, and whether this property can be partitioned among the existing persons who are there before the court.
And second point is that
अभी second point में मत आइए, पहले first point का जवाब.
first point तो हम
जजमेंट तो आप दिखा रहे हैं, लेकिन हम फैक्ट की बात कर रहे हैं. इसमें भी ऐसा
इसमें मिलता जुलता ही फैक्ट हम दिखा रहे हैं. इतना बड़ा जजमेंट
इतना बड़ा आप महल मुझे मार वाला कहानी कर दी जाके पार्टीशन सूट
इतना पेज में था दिखाइए. पेज में सॉरी पैराग्राफ 113 लॉस
113
and 115. In the case of the one hand, the obstructionist claim the title under one of the parties to the litigation. They set up the independent title in themselves. What was filed by the so and so was only issued to parties. In a suit for partition, the civil court cannot go into question of title unless same is incidental to the fundamental premise of the claim. Now, para 115 law, but in a simple suit for partition, the parties cannot assert title against the stranger even by impleading them as a performance model. The stranger who are impleading the partition may have nothing to say about the claim to the party, but they have a claim to title to the party. As such claim cannot be decided in partition.
तो आपका इंटरवेंशन ही गलत हो गया ना.
हाँ तो उसको चैलेंज भी तो नहीं किए ये लोग चैलेंज करना चाहिए था, इनको हाईकोर्ट में आना चाहिए था. चैलेंज भी नहीं किए. और दूसरा हमारे क्लेम को एडमिट भी कर रहे हो जो.
Heard the learned counsel for the appellant. The learned counsel for the appellant submits that the appellant was the intervener in the partition suit, and admittedly he was not a family member of the parties before in the partition suit, but claimed to be the title holder of the property. He submits that in such a case, the title of the intervener could not be gone into and decided by the learned trial court. He has referred to the judgment passed by Honorable Supreme Court reported in reported in AIR 2023 SC 3361, paragraph 113 and 115. He submits that in spite of intervention having been allowed, the learned court ought to have declined to enter into the claim of title of the intervener. He has referred to the proposed substantial question of law number 3. फाइव कैसे? फिर तो आप टाइटल डिस्प्यूट में चले जाइए. दोनों हंसना गाल फुलाना तो दोनों नहीं चलेगा ना.
दोनों नहीं.
कॉन्फ्लिक्टिंग नहीं चलेगा.
एक ही रहेगा.
एक ही रहेगा.
सही बोलो सही.
So far as the other suggested substantial question of law are concerned, they are essentially relating to title. However, since the appellant is submitting that in a partition suit, the title of a stranger cannot be decided even if he is made party.
Yes.
Therefore, there is no occasion to go into other substantial question of law.
Yes.
This appeal is admitted for final hearing on substantial question of law number 3. इसको ऐसे लिखिएगा for the following substantial question of law. Whether the title of the intervener, who is the appellant before this court, could have been decided in the partition suit. In view of the judgment passed by the Honorable Supreme Court, reported in 2023 AIR SC 3361. Trinity, I do not know what it is. Pyramida naam. Issue notice to the respondents.
61 respondents.
To 61 respondents within a period under ordinary process,
Only
for which recuses be filed within a period of 4 weeks from today. Let the records be called for from the concerned court upon deposit of special messenger post by the appellant within a period of 1 week,
2 weeks.
within a period of 2 weeks, post this case on 13th April, awaiting service.